offense could lead to your deportation.
Yes, Your Honor.
All right, and Mr. Guest, what is your plea to the DUI with serious bodily injury?
No contest.
Accept your no contest plea is freely, voluntarily, knowingly given. Adjudicate you guilty, sentence you to 60 months or 5 years in probation. $40 per month cost of supervision, $518 court costs, $1,000 fine, first offender DUI school, a victim impact panel, 5 years revocation of your driver's license, 50 hours of community service, which may be bought out at the statutory rate, impound of your vehicle for 30 days, substance abuse evaluation, any recommended treatment, random urinalysis, consume no alcohol, consume no drugs or controlled substances without a valid prescription, no contact with Randy Terry. I'm going to order restitution and reserve on the amount just for a period of 180 days. Anything that I've missed? Okay. Of $683 court costs.
Okay.
Does that change your decision?
No.
You understand that, Mr. Guest?
Yes.
It's going to be about
Yes, Your Honor.
$170 more in court costs.
That's fine. Your Honor.
Okay. All right, and this is a downward departure, as announced by the state, is based on an uncoerced plea bargain. I do need you to speak with probation, who's sitting behind you, Mr. Guest, and then I also need your fingerprints. You want to do that first? Okay, come on up to do the fingerprints first, then you'll talk to probation, and you have 30 days to appeal the judgment and sentence of the court. All right, thank you.
Costs and all the fines and fees that go along with that, in addition to what might be the restitution we request supervision.
Is there a request for that from the defense? And
The defense is neutral, Judge. If restitution is ordered, it is going to be an extraordinary amount of restitution. What we are trying to confirm is some of that has already been remedied through insurance. We don't know what the overage is. So in the event that
I'm going to keep the supervision cost in place until I find out that it's some sort of hardship, and then I'll address it if that comes to me.
Thank you, Judge.
All right, thank you.
I believe that's all I have, Judge.
All right, thank you, Ms. Merrifield. Have a good day. Is anybody else ready? Who's that?
Ms. Rivers.
Okay, sorry, I just couldn't hear you. All right, Ms. Rivers?
That's Crystal Pachasik. That would be 25 CF 904. She is present and approaching, Your
I
Honor.
think it's Paycheck or Paycheck. Yeah. Everyone says it differently.
She gets it so often that she just says whatever. Your Honor, in speaking with the state, we had hoped to resolve this today. They are still trying to get in contact with one of the parties, but the state did agree to stipulate to contact regarding the son Jace.
That is correct, Your Honor. The child victim, the state has no concerns about the contact, no violent contact with the child, and the guardian is on board with the child's request to let the child go, but we're not at that point yet.
And your,
How old is the child?
17.
Okay,
he's
that's
17.
what I thought. I just don't want to mix it up with anyone else.
And the other thing that I did not bring up with the state, but I did want to bring up now is, you know, he is at home. He doesn't, I don't believe he drives. So she would be asking to be able to go into the home as well. Now, previously, the adult son lived there, but he no longer lives there. And I think the state has even had trouble trying to locate him.
What about the husband? Wasn't there no contact or something between them at some point?
I believe that it is, Your Honor, so the state's not going to agree to that at this point. It has not been brought up, and I certainly wouldn't want to agree to it without at least running it by the parties.
She says she believes the no contact expired.
And that's what I'm trying to figure out, because
Yeah.
I don't want to give an order potentially, and I'm not saying I'm granting it, and find out that there's some other order in a different case that says that's going to be a problem. Let's see. Has there ever been a bond order other than first appearance, to your knowledge, Ms. Rivers?
We asked for a modification to allow her to be able to communicate with Jace when he sent her text messages. Other than that, no.
There aren't any injunctions in place, right? I just remember that there had been injunction cases
and they
at
all
some
expired.
point.
Yeah, and she said they expired.
Who else is residing in the home then?
My twin daughters and my husband. My dogs. 3 of the 5 children still live at home.
Yeah, I understand. This has been kind of ongoing for a couple of years now, and I'm just trying to get the current status of things so I know. what we're doing.
Resolution.
Is there anything that preventing him from having contact with you?
Are you
Michael?
aware?
It's Michael, right?
Are you aware of any no contact orders between you and him where he's
I
not
don't want to
allowed
be
have
in a
contact
situation
with you?
again where I say, you can go back to the home, and it turns out that means he can't be there anymore, and he,
No.
it just,
I'm certain that there's no.
all right, I'll allow for the nonviolent contact as well as return to the home. Obviously, if there's some sort of objection to that, we can address it.
Thank you,
If
Your
you can
Honor.
get me an order on that, Ms. Rivers, just so it's clear.
Yes, Your Honor. And Your Honor, we would just leave it set for the regular pretrial date.
We should have an answer by then.
That's going to be, what, April 27th at 1 o'clock?
Yes, sir.
Or we'll see you back then.
Yes, Your Honor. All the out of custodies I have, Your Honor, I do have in custodies.
Okay.
Your Honor, the first one is Shane Morrow. He's before the court on 22 CF 273. He also has 21 CF 2674, 21 CF 29, I can't read.
2998.
2998. Your Honor, he filed a motion to discharge counsel.
Okay. And I've reviewed that, and I don't think it's the first time either, right, Mr. Morrow?
Yes, sir.
I think the last time you filed it was technically against previous counsel with the Public Defender's Office, and you said you were okay with Ms. Rivers.
Yes, sir.
And now there's a new concern, correct?
Yes, sir.
All right. Is that what you want to go forward on to here today?
Please.
Okay. Can you raise your right hand? Do you swear or affirm the testimony you're about to give us the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Okay. Can you state your full name and date of birth, please?
Shane Matthew Morrow, 09/22/1992.
Okay. And I've reviewed your motion, but tell me what your concerns are with what Ms. Rivers has done or failed to do on your behalf.
Okay, I guess out of the motion, points 1, 2, and 3, I feel display a level of incompetence.
Well, tell me exactly what you're talking about.
Okay, I came back on an appeal with a reversal of conviction and sentence. Being sentenced, I was also designated as a predator. And so I had filed a 3800A removal of the predator designation
Okay.
due to the fact that I'm no longer sentenced and convicted of those charges. And by law, I can't have that statute or that status right now.
Okay.
I have talked to her about it. She failed to adopt my motion. So as far as that, I think the second point was mainly,
Well, let's go point by point. Are you done on that point? And I'm going to ask her a question. and then
Okay,
I'll-
yes, sir.
All right. Ms. Rivers?
Your Honor, we did review his request, and I believe he wants us to file a motion to address that status, and I don't believe that it really changes anything. He was originally sentenced on he's got 2 violations of probation. He was originally sentenced, no, I'm sorry, one violation of probation case.
Yes.
2 new laws. He was originally sentenced back on that case. He then violated that probation, and to now go back and address that, what we did is we pulled the records from his initial plea, and this goes to address one of his other points as well. We pulled the records of his plea colloquy. This was something that he voluntarily did, and we didn't see a problem, any problems with the plea colloquy and/or the sentence. And then once we get there, and again, this kind of bleeds on to another one of his points about manifest injustice and actual innocence. I then did case law research because he had his theories and whatnot, and I did case law research, and I did not see that that was something that we would win. I did not see that as, I saw more negative cases than I saw positive cases. And I did not see that as a viable outcome. I have pursued the manifest injustice before, and I had expressed my concerns prior to doing the research as to that. And I don't believe his allegations meet those standards. So I don't believe I have a good faith basis to file them. And so I expressed that.
All right, do you want to respond to that in any way, Mr. Morrow?
yeah, the research I've done as far as, so basically, I think there was a trilateral mistake at the time of my plea in my VOP case in 2017. I think everybody.
Well, let me make sure. What does 2017 have to do with this case?
All 3 cases are together. The violation of probation case has been the aggravating factor to go above my minimum guideline sentence. And so that whole case ties into.
Which case? You have to be more specific
okay, I'm
on the
sorry.
record, Mr. Morrow. You're saying this case and that case.
Yes, Your Honor.
Because
The
I can
violation
see
of
you've got
probation.
3 different case numbers, so.
The violation of probation case,
And what I understand, you're talking about 2017. All the case numbers I have are 21 and 22.
And Your
Okay.
Honor, and this is also in, like he talks about in his motion as well, and his allegations against the state attorney. This violation of probation case was originally over in Santa Rosa County. So once things got brought over here, there was a change in case numbers, and so that's, yes, so that's part of that. So when he's referring to his 2017 case, he's referring to the case number it went under.
And I'll tell you, when I was reading your motion yesterday, Mr. Morrow, for some reason you had like an underline where you put the case numbers and then you wrote them in. And it was really hard to read which case numbers you were referring to in the copy that I had. It was like you
Okay.
wrote it in pencil or something, and then, and when
Yes,
it
Your
was scanned or copied, I couldn't really read it, so it was kind of hard to follow exactly what you were saying, because I couldn't read the case numbers for which ones you were referring to. So I'm not trying to be, critical here. I'm just trying to explain to you why I'm having a little bit of trouble
No, I
keeping up
understand.
with what you're saying, because I couldn't understand it without doing a deep dive into old cases like that.
Yes, Your Honor.
And I obviously like to make sure I hear what you actually have to say about it.
So when I caught my new charge in 2021, which would have been the 2674 case number, that was originally started the prosecution in Santa Rosa County. At some point, the information was amended, reflects the charges were committed in this county. There was a motion filed from the state to change jurisdiction from Santa Rosa County over here to Okaloosa County, under the guise of efficiency, the judicial economy. There's about 3 or 4 cases regarding that same issue, and that was not an appropriate reason to change jurisdiction.
Did you appeal that issue?
No, Your Honor. These are some concerns I brought up back in '22 with my paid counsel
Okay.
that we ended up being in a conflict with as well, or I was. But the violation of probation case also got moved over here as well, as Rivers was saying,
Ms. Rivers?
Ms. Rivers. And that case is what allowed me to get the designation as a predator, allows for the state to recommend a harsher punishment due to the nature of that charge. And back in 2017, when I caught the offense, I pled up to a 5-year probation sentence.
What did you plead to?
No contest.
No, what charges did you plead to?
Lewd and lascivious conduct, 3rd-degree felony.
Okay.
And
And which case number did that become, do you know?
2998C.
Okay. All right, go ahead.
The research I've done, I understand I'm 9 years overdue to bring this argument up. I know a 3850 has to be done within 2 years. Unfortunately, I was not aware of the issue at the time, plus on probation, no internet access. I'm not trying to make an excuse, but that's really what it boiled down to. Also, I had paid the same counsel that I had with these new charges back then as then 2 years ago. And I think what ultimately, there's a case on the law library that is almost exactly on point with my case. And I'm not trying to go too far into all this other stuff, but I believe there was a manifest of injustice where I pled up to a crime I did not commit. Ergo, the one element of the crime I didn't satisfy, and the state, as well as defense at the time, stipulated to a factual basis. The only factual basis,
So you stipulated to the factual basis,
yes, Your Honor.
and now you're just saying I didn't do it.
Well, no, the actual element of the crime is not present.
But you stipulated that it was.
Unknowingly,
Which case are you referring to?
the 2998C, the violation of probation case. And so we're all.
So you want to attack your VOP by saying you should have never actually pled in Santa Rosa County
In essence.
in the 2017 case?
In essence, yes, Your Honor. I feel that if what I'm claiming to be an actual manifest of injustice, it would invalidate the sentence.
What is the manifest injustice? That
Being-
other than you're now saying I didn't do it,
Being convicted of the crime I did not commit, yes, Your Honor.
but you admitted it before
Yes,
and
Your Honor.
stipulated to a factual basis before.
I think we all misunderstood what the actual term of solicitation was compared to what was actually the conduct that was actually occurred. It didn't rise to the level of solicitation.
But you didn't appeal anything, right?
No,
In
Your
that
Honor, I did
case.
not.
And you didn't file a 3850 in that case.
No, Your Honor.
So, and as you've stated, it's now 7 years ago.
Yes.
So what do you expect to do on that one? Have you provided anything to Ms. Rivers as far as the case that you're referring to?
Yes, Your Honor. I've actually wrote almost a 20-page motion to dismiss that case with extensive case law. everything from the actual charge to a vehicle of bringing forth this argument in front of the courts through another case. And
So wouldn't I have to send this back to Santa Rosa County? If that did happen?
sir,
So wouldn't I have to send it back to Santa Rosa County for all that?
I mean, with my second point of this court shouldn't have jurisdiction over that case, yes, but at the current moment, this court does have jurisdiction over the whole entire case. So there's a lot of case law that talks about fundamental errors.
Let me stop you, Mr. Morrow, because I do this to lawyers very often too. I don't accept people telling me case law says. Unless you
Understood.
want to cite it, I'm not going to entertain the argument about it, because otherwise anyone could just say, case law says, and give me something that's completely fabricated.
Understood.
Especially in
Unfortunately,
today's world of AI and hallucinated case sites and things like that, that lawyers are being sanctioned for. So I don't accept case law says.
Okay,
So if you want to provide me something, you can certainly do that.
Yes,
But I'm
sir.
not going to entertain this issue at this point.
Okay.
You've provided this 20-page motion you've written to Ms. Rivers?
That's correct.
And have you reviewed it, Ms. Rivers?
Yes, I have, Your Honor. And I did do my own case law research, and I spent an afternoon with him, right, a month or so before he filed this motion, where we went back and forth over, why I don't believe this is valid.
Okay, and do you understand that lawyers have, Mr. Morrow, lawyers have an obligation not to file motions and pursue them if there's no good faith basis to do so?
understood.
Okay. What else would you like to talk about?
The fifth point of my motion really goes to what I think me and her don't see eye to eye that creates the conflict itself, is moving forward with the actual new law violation case. There's a defense that I want to pursue,
Okay.
and she's unwilling to, for basically the reasons you had just stated.
About what?
Frivolous motion or.
Well, it's not,
good
I'm not,
faith.
yeah, good faith basis.
Understood. And me and her don't see eye to eye on that, and my takeaway is there was two other attorneys in the Fort Walton courts within the last year that have argued the exact same argument that I'm trying to make now. And not only did they both file motions, the state entertained both of those motions, as well as the judge wrote his own opinion about that issue.
Again, this is kind of like saying case law says. I don't know what you're referring to. You're
Okay.
saying lawyers in another court filed motions similar to the ones that you're not explaining to me, and they were entertained.
Okay,
And
so-
and an order was were they successful?
They were unsuccessful, but ultimately they ended up getting a better deal. So I feel.
And how
that there was-
and how am I to determine that, based on what you've told me?
Okay, so the motion I was trying to get filed was a motion to dismiss. Basically, law enforcement had broke the law
Okay.
and violated the actual statutes. It's a very different argument that's been made in prior courts and stuff. I feel that it's
I understand you're not trying to, show your cards here, Mr. Morrow, but to tell me I should have her taken off your case because she's not pursuing something, yet I don't know what it is that she's not pursuing, it makes it kind of hard for me to make a determination that she's been ineffective in some way.
Okay, so I don't feel that she's pursuing my argument as such, that she's saying good faith won't allow her to file a frivolous motion. But
Okay?
yet, there's been two other attorneys, and I know you just,
Two other people have filed similar motions and they were denied.
yes, Your Honor. But it was a valid defense that is now being pursued in the district courts on an appeal. And I feel that without pursuing this, I mean, that's just another thing that I'm not going to be able to raise later on down the road. And so I'm trying to pursue all the defenses I can. This argument also is to be decided as a matter of law.
I don't know what the issue is yet, Mr. Morrow. A motion to dismiss can be for any number of things.
Objective entrapment
Okay.
would be the issue.
Okay,
that
and
I'm
I
trying to
can tell
pursue.
you, I've dealt with those cases. I don't know the facts of your case well enough to make that determination as to whether it is, but I can tell you as a former defense lawyer, I was unsuccessful on such a motion before on a case like yours.
I understand.
So I'm not, again, if she's saying she doesn't have a good faith basis for it, and then what you're ultimately doing is putting a lot of your defense out on Front Street, that you're then telling the state what it is.
Yeah.
Maybe a
Unfortunately, I
strategic.
didn't want to, but when you kept saying you
Well,
don't.
no, what I'm saying is to pursue it in a motion, put it in writing, put it in front of the court, put it in front of the state, and then it gets denied. Now you've kind of shown your cards as to what your potential trial defense is. I'm not, that's a strategic issue, but she's also saying, we're not going to win it, so I'm not going to file it. And you haven't really given me any reason to believe that there's a valid defense here.
Well, the defense hasn't, I feel through the research that I've done that this is a valid defense. This defense is only decided by a matter of a judge and not a jury. Therefore,
It's not accurate.
objective entrapment,
You can argue entrapment to a jury.
well, subjective entrapment.
Sure.
But the argument that I'm making is a matter of law. If by the plain language of the statute, did law enforcement break the law? And I don't think a jury is going to be able to decide that. But regardless, I feel the fact that other attorneys have pursued the same.
And
issue-
lost, right?
Well, essentially, yes, Your Honor.
All right, anything else as to your Nelson inquiry, Mr. Morrow?
Pertaining to this Nelson hearing, I believe my old public defender is in the same public defender's office as Lisa Rivers.
But you abandoned that, right?
Due to the,
Early on, when I took over your case, you had filed a Nelson inquiry, and we came to court, and you said, no, I'm fine with now that I've got a new lawyer, I'm abandoning that.
yes.
So now you want to claim, you want to go back and talk about what your previous public defender failed to do over a year ago.
Well, yes and no. And I say that because I came in that day to have a Nelson hearing. I was told by counsel that
By
my
who?
case had just been removed.
Hold on. Who's counsel?
J.D. Williams, my old public defender,
Jay Williams.
J. Williams. Yes, Your
Okay.
Honor. And so when I came into court, he had essentially told me that your case had now been moved. You no longer have me on the case, that you have been appointed to Lisa Rivers, Miss Rivers. And so at that point, I didn't think it was necessary to go through with the.
I
Nelson
understand that, and you didn't go through that, which means you've abandoned those claims at that time.
Uh-huh.
Now your motion, your Nelson motion doesn't talk about that other than saying that there was, you kind of imply in your motion that there was a previous finding by the court of ineffectiveness when there was never a hearing on it. And so now you're trying to say the public defender's office as a whole should be removed from your case because you made claims about 16 months ago that you never pursued.
Yes, Your Honor.
Denied. All right, anything else for Mr. Morrow?
If I could just indulge you with,
I think we've gone through that, but what issue, because we've covered all of the issues in your motion, right?
sort of.
Well, tell me what we haven't covered yet.
Okay, so this is how everything stems together. So October 29th of 2024, my first court date back from my appeal. Judge Gonteric had asked why I was given the public defender's office. Jay Williams had stated, because he was not in a conflict with our office, he had private counsel. He also then stated that he would further pursue any conflicts, and if there was, he would withdraw from the case.
Okay.
Moving forward, December 5th, which is the day I guess I had withdrawn my plea, that day came, I didn't feel he was doing an adequate job, and there was issues, I believe, put us in a conflict. Therefore, when I got in the courtroom, he had stated to the judge, Gonteric, that he was going to,
Well, let me stop you, Mr. Moore, because this is the way I see this case. When your case went to the first DCA, it was reversed and remanded, right?
yes, Your Honor.
And what I'm looking at it right now, what it says is, we reverse the convictions and sentences and remand with directions to vacate the order denying the motion to withdraw a plea. And to appoint conflict-free counsel.
Yes, Your Honor.
But what that court did when it came back was to not only, it vacated more than just the order denying the motion to withdraw.
I'm not following.
That you came back, a lawyer was appointed, right? So what's the conflict?
So,
Because the public defender was not your counsel that was part of the appeal, right? In fact, the public defender's office is the one that won your appeal. Correct?
the appellant public defender's office, yes. That would be like Jessica Yearly's office,
Erie,
Yeary.
yes. She's the public defender for the Second Judicial Circuit who handles appeals.
Yes. But
So
when
the
I-
public defender's office won your appeal, and then now you've come back and you're saying, I have a conflict with the public defender's office, but you haven't told me what that conflict is, other than your Nelson inquiry that we just had.
The
And then you
conflict-
started talking about October and December of 2024, and I'm trying to get you to get to your point.
So my-
I'm not trying to be difficult, Mr. Morrow.
No, I understand, I
But
understand.
we've been at it for a while here, and you haven't really explained what you're trying to get at.
What I'm trying to get at is, from my understanding, the reversal was to come back and be appointed counsel where I wasn't in a conflict to try and withdraw my plea. At the time of.
I agree with that. I think that's the issue. I think there should have been another hearing as to whether or not you could withdraw your plea.
See, and there
And
wasn't.
instead, what the court had done at that point was withdrew your plea without an argument.
Yes, and that, I'm not okay with that. The reason why is because that limited to, what was the reason that I withdrew the plea? And at the time of me trying to withdraw the plea, I alleged a conflict. I ended up,
A conflict with whom?
with Jay Williams.
But he wasn't your lawyer then,
Well, he
right?
was.
Who was your lawyer when you initially pled? Randy Etheridge,
Yeah,
right?
Randy Etheridge, yes, Your
Okay.
Honor.
So what does Jay Williams or the public defender's office have to do with it?
Because when I came back here, he was who was counsel. I didn't see anyone else. He was the one who said.
You
he
were
was
appointed a
on-
public defender.
Yes. And after talking with him, some of the things that he had told me, I thought there was a potential for a conflict due to the nature of everything that he was stating to me. So when I came in court that day, I had said I wanted to discharge him due to a potential conflict.
And then you didn't pursue it. We're chasing our tail here, Mr. Morrow.
No, so, but in essence, the court deviated from the mandate. My opinion is they deviated from the mandate because I was never given true conflict-free counsel at the time of me withdrawing the plea. The state just conceded, and I ended up, when I got Rivers, I ended up
Miss
asking her.
Rivers?
Miss Rivers. I went to ask her, did I withdraw my plea? She went back and said, yes, you did, back in December. I was unaware of that. I would have liked to know for the record, what was the reason for me withdrawing my plea? Because to me, it makes a difference. And so that's where I feel the issue with prior counsel plus my issues now with counsel, I just feel that there is a conflict with the entire office.
I disagree. Your Nelson request is denied. You can't abandon that and then over a year later try to bring it up without, you're treating it like there was a hearing and it was determined that Mr. Williams had done something ineffective.
That's not what I was trying to get at. I feel that it's compiled.
And what's the
up.
conflict? I'm not gonna, do you want me to go back and read your motion from over a year ago? What was the conflict that you cited in your motion?
The conflict was, well, basically I stated reasons why I should withdraw my plea, good cause or to show good cause. But the conflict was that his potential friendship with Randy Etheridge was what I believe the conflict to be. He went in.
Let me explain something, Mr. Morrow. This is a relatively small area. Everybody knows everybody to some extent. I know Mr. Etheridge. I can tell you about 1,000 conversations I probably had with him sitting in the benches waiting for court cases to be called. That doesn't mean I have a conflict because I know who he is and may have talked to him in the past. And unless you're claiming because of that friendship, Mr. Williams did something improper in your case, which is not what you're saying.
No, that's not what I'm saying.
All right. So,
Well, if my Nelson hearing is denied, what's my option? If I want to pursue my defenses and counsel's unwilling to pursue these defenses,
you're free to file something new that explains what your concerns are, but everything you've given me is very vague. And you said you've given things to her, and she's told me that she's reviewed them, done her own research, and doesn't find a good faith basis to do it.
okay.
But I don't know what it is, other than now you've given the term objective entrapment. But I don't know what your concerns are, what you've brought her. I'm not trying to delve too far into your attorney-client relationship, other than that you've asked me to do so. But I don't know that she's wrong.
I think the fact that two attorneys have pursued it, just
And
for it to be on the
lost.
record, I understand they lost, but they have an avenue for an appeal. And I
But they
mean,
haven't won those appeals, right?
no, sir, they're ongoing.
I don't know that, other than what you've told me. I don't know what cases you're referring to. You referred to cases, you referred to lawyers, all generally without specifics. So how am I supposed to make a determination as to whether or not Ms. Rivers is wrong if I don't know what the issue is and you haven't given me the sites that you're referring to?
I don't know what the private attorney counsel is, but I do know the public defender that made the argument, which was Scott Klein's. I think the paid.
Scott
counsel-
Klein's, who works for Regional Office of Conflict Counsel and who would be your lawyer if I discharge the public defender, right?
I do believe so, yes, Your Honor.
Okay. Your Nelson inquiry, as I've stated several times now, is denied without prejudice that you can refile it if you want to give more specifics.
Okay.
Thank you, Mr. Morrow. That's all we have for today.
Yes, Your Honor. Am I able to appeal this to the district court?
You can certainly appeal anything that you'd like.
Okay, thank you.
Adam Richardson? Your Honor, this is Adam Richardson before the court on 24 CF 78, 24 CF 2847, violations of probation. We've reached an agreement in this matter, if I may approach.
Yes, please. Thank you. Mr. Richardson, can you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Can you state your full name and date of birth, please?
Adam James Richardson, 11/25/2000.
All right, and Mr. Richardson, you're here in 24 CF 78 and 24 CF 2847, charged with violations of probation. Do you understand that?
Yes.
I've been given a plea agreement that calls for you to admit that you violated your probation. And the agreement between you and the state would be to reinstate and modify that your first year of probation will be on community control. You must enroll in the batter's intervention program within 30 days. $100 cost of prosecution, $100 PD fee, $50 application fee, and a waiver of your cost of supervision. Is that your understanding of the agreement?
Yes, Your Honor.
Is that what you want to do here today?
Yes.
Is that the state's agreement?
Yes, Judge.
All right, thank you. All right, and Mr. Richardson, have you had enough time to go over this form with your lawyer?
Yes, Your Honor.
Did you understand and sign it?
Yes.
Are you satisfied with your lawyer's advice and representation?
Yes.
Are you currently under the influence of any alcohol, drugs, or controlled
No.
substances? Are you currently, and that's just for the record, Mr. Richardson, if you talk at the same time, it kind of muddles it up a little bit. I know you know the questions and what your answers are going to be, just wait. Are you currently suffering from any mental health issues?
No.
Has anyone forced, pressured, or threatened you in any way to enter this plea?
No.
Has anyone promised you anything other than the terms of the agreement I've just read?
No.
And do you understand if that you admit to your violation of probation, that there won't be a hearing where the state would have to prove that you violated?
Yes.
And do you understand you're waiving any potential defenses that you may have to those violations?
Yes.
All right. Given that, what is your plea to the violations of probation? Are you admitting or denying them?
Admitting.
All right, I'll accept your admission as freely, voluntarily, knowingly given. Reinstate and modify your first year of probation to be community control. Enroll in batter's intervention program within 30 days. Make sure you get on top of that. I know there's been some switch in providers and things. So, Mr. Barry, do you want to state anything about that?
Yes, sir, Your Honor. The only place that it affords batter's intervention between here and Pensacola is Walton County. I can refer him over there, but I can't tell you that they can, and it's gonna cost them to enroll. So if we can't get him
I
enrolled, or he
thought there
can't,
was something new.
I just don't want him to get in a bind that he comes in and talks to me and I send him over to the one in Walton County and he doesn't have the money to pay for it and they say he never enrolled and then we're right back here.
Okay. I thought there was either one had been approved or there was another one in the pipeline, but I just looked at the last email I have that has the link to the Department of Children and Families list. And when I filtered by circuit, Defuniak, Lakeview is the only one that has it listed. Maybe I just
Would you agree to give them more time?
misunderstood because I always think of Lakeview as Pensacola, but
Right. I knew that there were some other people trying, but you run into that little catch-22.
okay. Well, Mr. Richardson, you're always going to have to make your best effort. I don't expect Mr. Barry or anyone from probation is going to violate you unless they think it's a willful violation. So you're going to have to do your best to get that done.
Yes, Your Honor.
Your Honor, in speaking with the state, she would agree to allow more time considering there's only one provider and it's over in Walton County.
Okay.
Asked if she would agree to 90 days to get him, to allow him to be enrolled since he's gonna have to pay for it.
Any idea on cost?
No, Your Honor.
Mr. Barry,
I couldn't hear, I'm sorry.
what the cost of that program?
Couple of hundred to get going, and then it's, I want to say it's about 100 at a time,
That's 26 weeks, right?
26.
All right. Based on the agreement, I'll change it to 90 days. I still think, don't wait till day 82. I would try to do it as soon as you can, Mr. Richardson. Otherwise, if that's what the attempt is, and it's going to look like you waited too long. So I will get right on top of it the best you can, but I'm not going to have you get violated because the program that you've been sentenced to is not easily available to you. Okay. All right, just to go through the rest of it, it's $100 cost of prosecution, $100 PD fee, $50 application fee, and a waived cost of supervision. Mr. Richardson, I do need you to speak with probation, Mr. Berry, who's sitting back there. Was this a modification? Yes,
It is a modification,
okay.
right?
All right. Thank you, Mr. Richardson. You have 30 days to appeal.
And same terms on everything else?
Yes, reinstate all previous terms.
Thank you.
Your Honor, this is Clifford Richardson before the court on 24 CF 2764. We've reached an agreement in this matter, if I may approach.
Yes. Would you be able to work in Klein's or no? 'Cause I know he's. All right, Mr. Richardson, can you raise your right hand? Do you swear or affirm the testimony you're about to give us the truth, the whole truth, and nothing but the truth?
I do.
All right, and can you state your full name and date of birth, please?
Clifford Gene Richardson Jr., December 22nd, 2005.
Okay, and Mr. Richardson, you're here in 24 CF 2764, where you are charged with possession of forged notes.
Violation of probation, Your Honor.
It's a VOP, okay. That's what I would have figured, but I was going to put in parentheses VOP. All right, it's a violation of your probation, Mr. Richardson. I've been handed a plea agreement that calls for you to admit your violation, be 60 days county jail, revoke and terminate your probation, $100 cost of prosecution, $100 PD fee, and a $50 application fee. Is that the agreement that you've made?
Yes, sir.
Is that what you want to do today?
Yes, sir.
Is this the state's agreement?
Yes, Judge.
Okay. All right, Mr. Richardson, did you have enough time to go over this agreement with your lawyer?
Yes, sir.
Did you understand and sign it?
Yes, sir.
I'm just going to add a date here. Are you satisfied with your lawyer's advice and representation?
Sir.
Okay. And are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues?
No, sir.
Has anyone forced, pressured, or threatened you in any way to enter this plea?
No, sir.
Has anyone promised you anything other than the terms I've read?
No, sir.
And do you understand that by entering the plea, there won't be a hearing where the state would have to prove how you violated?
Yes, sir.
All right. And do you understand you're waiving any potential defenses that you may have?
Yes, sir.
All right. And what is your plea to the violation of probation? Are you admitting or denying it?
And admitting to it.
Okay. I'm going to accept your admission as freely, voluntarily, and knowingly given. Revoke and terminate your probation, sentence you to 60 days in county jail, credit for time served, $100 cost of prosecution, $100 PD fee, and a $50 application fee. Was he adjudicated on the underlying? All right, so this is an adjudication of guilt, so that's a felony conviction for you. Do you understand that, Mr. Richardson?
Yes, sir.
All right,
We did talk about what it means to be a convicted.
okay. Any questions about that, Mr. Richardson?
Yes, sir.
Okay. All right, I do need you to be fingerprinted now that you've been convicted or adjudicated guilty of that felony, and you have 30 days to appeal the judgment and sentence of the court. Thank you, Mr. Richardson. Step up and be fingerprinted.
Outstanding money to collection.
Yes, sir.
You want to finish, Mr. Rivers?
Yes, finish, Ms. Rivers, and then we'll.
If you could hold him to where I can talk to him. Rudd? Your Honor, this is Lawrence Rudd before the court on 24 CF 2754. He had asked me to set this for status. We had done depositions.
My note is status of what? It just came up as status hearing, but it didn't say what it was about.
Well, he has a new law case. We had conducted depositions. Based on those depositions, the state was modifying the score sheet. And he wanted to know what that would be, to see if maybe he could resolve the case today. I did inform him, what the new score sheet is. He does not wish to take the state's offer. So, he did indicate to me that he wants to pursue a downward departure based on medical needs. So we're gonna do that.
Okay. So what's he gonna do today?
Your Honor, he would continue with a denial of
Okay.
his violation of probation.
And what is the status of his new law?
He is set for the 29th.
Ninth? Okay. Do you want this one to run with that, or you want to keep it on a miscellaneous docket?
Your Honor, to run with it's fine.
Okay. Issues with the state?
The state's gonna seek a violation of probation hearing,
Okay.
and the offer was initially 60 months. The state yesterday extended.
Just to make sure, 60 months DOC?
Yes, Your Honor.
Okay.
6 months DOC, so the state redid the score sheet based on the facts and circumstances presented to it in depositions. So we redid it, that's 18.7 months in DOC. That offer is not good after today.
Okay. Do you understand that, Mr. Rudd? Yes? Okay, so you understand that the offer stands for only today 18.7 months? Yes?
Yes.
And then has that been conveyed to you previous to today?
No, Your Honor, it was conveyed today.
Today, but
Because I
before you
got it.
came into court?
Yes, Your Honor.
Okay. And do you need more time to speak with Ms. Rivers about that?
No.
Okay, so you're rejecting that plea offer at this point?
Yes.
Okay. All right. What date would you like to set the VOP?
I wouldn't say the earliest, other than the 9th, but it's Your Honor's next EOP.
I know things got moved around when they were doing all the modifications up here. All right. The 23rd. The 23rd shouldn't be on there. All right, we can do April 30th. There's one case on April 23rd. It's one of yours, Miss Rivers. We're going to have to get that reset. I'm in a civil jury trial that week. It may have just been an oversight.
We have that on our calendar, Your Honor, so we'll correct it.
I think the only one that's on there is this one case, Richard Stewart. Maybe a restitution hearing.
Didn't even know anything about it.
Well, it's going to have to be moved.
23rd, I'm sorry.
We're setting Mr. Rudd on the 30th at 2 o'clock with subpoenas, unless you're asking for a continuance for some reason. If the state's ready. Okay. But I'm just bringing up the one that's set on the 23rd, this Richard Stewart case, just to make sure we can get that moved.
Yes, Your Honor, I'll make a note of that.
Because I'll be in a, it may be done by that point, but I can't. We've got another hearing on that case tomorrow morning, so I'll find out if it's still going. But at this point, I may be in an all-week trial. All right, so April 30th at 2 o'clock for the VOP is an evidentiary hearing, and then his other case is still set for the 29th of April,
Yes, Your Honor.
so the day before. All right, thank you, Mr. Rudd.
Your Honor, in speaking with Mr. Smith, he is very stressed about getting the appropriate credits before he gets sent off to prison. I'm going to have to try to see what I can get from the state of Alabama and the rehab center. There is notations in the court records about getting credit. It just doesn't list the days. So at this point, I'm going to ask to put this on for April 30th. Because he is going to be.
Without subpoenas?
Yes, Your Honor, because he is going to be doing a DOC sentence.
Okay. Any issues from whoever has this from the state?
That would be Ms. Flowers.
Okay. Today it is.
Yes, sorry, I was speaking to Mr. Williams. What was that?
We're just moving this case to the 30th without subpoenas so they can figure out credit.
No, Judge.
Okay. All right, April 30th, 9 o'clock.
Your Honor, I just need just a moment with Mr. Strickland so he can sign his agreement.
This is your last one?
Yes, Your Honor.
Okay. I'm gonna get Mr. Klein set up to go next.
Your Honor, and this is James Jasper Strickland, 25 CF 864. We've reached an agreement in this matter.
All right, Mr. Strickland, can you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, can you state your full name and date of birth, please?
James Jasper Strickland, 04/13/1992.
All right, Mr. Strickland, you're here in 25 CF 864, where you're charged with 2 violations of probations on misdemeanor cases, or misdemeanor counts. Do you understand that?
Yes, sir.
All right, and I've been handed a plea agreement that would call for you to admit your violation. In return, it'd be 30 days county jail, revoke and terminate your probation, $100 cost of prosecution, $100 PD fee, and a $50 application fee. Is that the agreement you've made?
Yes, sir.
Is that what you want to do today?
Yes, sir.
Is that the state's agreement? All right, did you have enough time to go over this plea agreement with your lawyer?
Yes, sir.
And did you understand it?
Yes, sir.
Did you sign it?
Yes, sir.
Are you satisfied with your lawyer's advice and representation?
Very much, sir.
All right, and are you under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues?
No, sir.
Has anyone forced, pressure, or threatened you in any way to enter this plea?
No, sir.
Has anyone promised you anything other than the terms of the agreement I just read?
No, sir.
And do you understand that by entering an admission to your violation of probation, there won't be a hearing where the state would have to prove how you violated?
Yes, sir.
And you understand you're waiving all potential defenses?
Yes, sir.
Was this an adjudication of guilt?
Yes, Your Honor.
Okay. Okay. What was he charged with?
$50. 100.
I'm gonna get his fingerprints. I think there's the potential for the count 1, the cruelty case. I think that's becoming enhanceable. So I think for that purpose, we would have to get his fingerprints. All right, Mr. Strickland, what is your plea? Are you admitting or denying your violation?
Admitting.
All right, I'm going to accept your admission as freely, voluntarily, knowingly given. Revoke and terminate your probation, adjudicate you guilty, 30 days Okaloosa County Jail, credit for time served, $100 cost of prosecution, $100 PD fee, and a $50 application fee. I'll need your fingerprints as I've stated, and you have 30 days to appeal, Mr. Strickland.
Yes, sir.
All right, thank you.
And outstanding monies to collection.
Yes, outstanding money to collection. All right, Mr. Kleins, can you hear me?
I can, Your Honor.
Okay, sorry about the delay, but I turned the Zoom on right away, and I know you were running a little late because of your email that you sent us, but here we are.
Yes, sir.
All right, looks like, well, why Why is the picture-in-picture thing not working? That's our first day using the new system. I worked it all yesterday in preparation, and then now the picture-in-picture is not working, so.
Understood.
So you can see me, but I can't, try to get it to switch over to the courtroom so you can see your client, and it's not doing that. It's probably because it's on basic mode. All right, so first person we've got is Mr. Fell, correct?
Yes, Your Honor.
Okay. And
And
Mr.
so the court's aware, I met with Mr. Fell and with Mr. Robbins. I did not meet with Mr. Presley, but both Mr. Fell and Mr. Robbins are aware I'm gonna be on video today.
Okay. Oh, wait. As you can see, the courtroom's changed, as someone has heard what I had to say and then is fixing it for me, so thank you.
Awesome.
All right, Mr. Fell, I know we're here regarding your motion to correct, I guess, the sentencing errors. I'm working on it. Unfortunately, I didn't get it finished, and it being a deeper dive than I expected it to be. And to be honest, I actually went back and listened to our hearing from last time, and I told you, I'm gonna go put it up on the whiteboard and I'll get right to it. And then I put it on a note, and when we didn't finish court till 5 or 6 o'clock, I forgot to put it on my whiteboard, which I didn't recognize it until late last week, and just haven't been able to finish it up because it wasn't in my queue, and that's my fault. But I do have a day next week. I plan to catch up on a couple of things like that. Yours will certainly be done, so I'll have your order to you next week. All right, and again, I apologize to you and Mr. Kleins in the state about that. It's just sometimes, the court makes, I don't want to say mistakes, but just doesn't get to things in as fast as it would like to, so.
No, I understand. Does the court want to put this on the April 9th docket for status?
We can certainly do that. I know that's what today was supposed to be for, and unfortunately, just between the calendar and me forgetting to put it on the board, I didn't get it done. But I expect I'll probably have it done by the end of next week. And then I think what we talked about last time too, Mr. Kleins, is once you receive it and talked about it with Mr. Fell, if you don't have any issues, you can certainly cancel that status hearing set for April 9th at 9 o'clock, and just go from there. But
We'll do that, and Mr. Fell, what I'll do is I'll keep an eye out for, I get a lot of service court document type emails, but I will definitely be paying extra attention. Once I see the order come through, I will come to the jail and go over it with you. If we have to cancel there's really no point in coming to court on the 9th if the ruling has been issued. I know you want to get out of DOC and start getting your game time.
And if we can get this done within like a week, 2 weeks, I don't mind sitting at the jail a little bit longer.
Well, the court date will be in 2 weeks. I expect I'll have the order done next week. And I know I said I would have it done for today, but, I apologize for that, Mr. Fell. It's just, I don't want to say it's a novel issue because it's based on another case, but how that case really works with all these other issues I think it's a kind of a first impression for most courts, let alone me. So I want to make sure I'm looking at it from all angles and getting it right. So, all right. So we'll see you back April 9th, 9 o'clock. Again, if you need to cancel it, Mr. Kleins, you certainly can, but if you all talk about it and there's something you want to bring back to my attention, we can keep that date for that purpose.
I will, once I see the order, I'll go talk to Mr. Fell. If we file a cancellation, I'll let the court know, but,
Okay.
yeah, that's fine.
All right, thank you all.
Mr. Presley?
All right, this is Mr. Presley. We're here in 25 CF 1586. Mr. Kleins, I think what we talked about last time is, the Florida State Hospital, and there was some discussion about emails, and I don't see that I ever received them about kind of the exact need that was to be done, and then this was really kind of the reminder about getting the order.
So the issue with Mr. Presley, I will double check to make sure. I thought I sent the email to Your Honor like the day of the last court hearing, but I'll make sure you have it today.
I searched for it yesterday and couldn't find it, so.
Fair enough. I'll resend it as soon as I'm done with court.
Okay.
The problem with Mr. Presley is that Dr. Klein's recommendation was to put him in the dementia unit at Florida State Hospital. Unfortunately, the dementia unit is under the jurisdiction of the Department of Children and Families, and Mr. Presley has been found incompetent and is going to be committed under the Agency for Persons with Disabilities.
Okay.
So our point person, anytime we have these intellectual disability issues, we talk with an individual named Joseph Sanchez with the Agency for Persons with Disabilities. Mr. Sanchez has already reached out to Dr. Klein to see if he can clarify his recommendation. My understanding is Dr. Klein is out of the office, is on some kind of vacation or something like that. So as soon as Mr. Sanchez hears from Dr. Klein, I will confer with Ms. Boss. So that's the reason why the court hasn't seen an order, is because last time we were in court, we were like, yeah, we're going to send him here. And then Mr. Sanchez, about 4 days after that, give or take, was like, yeah, we can't do that because it's a different agency. So so that's why we're waiting on Dr. Klein to get back with us and maybe alter his recommendation or see if there's a way. I don't know, but that's why the court hasn't seen the orders, because what we talked about in court last time doesn't sound like it's legally possible.
Okay, understandable. But if you could just forward those emails to me again so I can take a look at them, and you may have sent them and they disappeared somewhere, but I searched my entire inbox and deleted files and everything else, so.
Yes, as soon as I'm done with court, I will, after I take off my jacket, I will then search for those emails and get them to your assistant today, before lunch.
All right, I appreciate it, Mr. Klein.
Yes, sir.
All right, Mr. Presley, when do we want to have him come back?
If we can have him on the April 9th docket. Hey, Larry, today is Thursday. I'm going to come talk to you on Monday afternoon, okay?
Yes, sir.
Okay,
Oh, yes, sir.
Okay.
all right.
So, yes, sir. We can leave this on for 4, 9, and 9 o'clock.
All right, April 9th at 9 o'clock, we'll see you back on that date, Mr. Presley. Mr. Klein is going to come talk to you on Monday.
Okay, yes, sir.
Have a good day.
You too, sir.
Thank you. All right, this is Devin Robbins, correct?
Yes, sir.
All right, 21 CF 2891, Mr. Kleins?
So, Your Honor, this is his arraignment. Yesterday, I had filed a bond motion for Mr. Robbins, and I received an email from Mr. Sprouse. Mr. Sprouse, I had texted you a little while ago. I didn't really understand what the email meant. I didn't know if you were stipulating to the bond motion or if you were going to dismiss the VOP. I'll turn it over to you to kind of. I didn't understand what you meant.
I was stipulating to the bond motion.
Okay.
Okay. So, Your Honor, yesterday I had filed a motion. The allegation with Mr. Robbins is that he did not attend some psychological treatment sessions that he had in early January. This is his first case that he's ever had. He has no priors. This is his first allegation of violating supervision. His term date isn't even until next April. So I had filed a motion for, I believe, $1,000 signature bond for Mr. Robbins. It sounds like the state is going to stipulate to that motion. And the intent really is to get Mr. Robbins out on bond so that he can get into those psychological treatment sessions. He's already been ordered, he's done his evaluation, but he's been ordered to have these psychological treatments. And in early January, he didn't go to a couple of these meetings, and he was basically violated for that. So
From my reading of the affidavit and the violation report is that he was supposed to go to appointments on January 6th, January 7th, and February 4th, and he was a no-call, no-show to 3 consecutive appointments, so they discharged him from the program.
That's correct. That's the allegations. I have talked to Mr. Robbins. I have stressed to him that these aren't optional. I can tell the court, I mean, the violation report itself says that Mr. Robbins was working temp jobs, and I mean, those could be chaotic. I know what the allegations are in the report. But this, I mean, he's even made court cost payments. He's been making progress toward getting these cases resolved. And it's a 21 CF case. I don't know why it took 3 years to plead. I mean, it was pled in 2024, I believe. So, again, this is his first violation. He has no prior record. So the intent of this request for bond is essentially to get Mr. Robbins out, knowing that sometimes with people who don't have prior record, they don't really truly, and I'm not saying this is an excuse, but sometimes they don't truly understand like how serious a violation can be. He's been in custody for, I believe, 38, 39 days at this point. There was a withhold of adjudication. Count 1 in this case was dismissed as part of the plea, so there is no aggravated battery. It's just 1 count of failing to stop for a crash involving injury. I'm trying to show the court and the state that Mr. Robbins can comply with what he's being told to do. And that's why I looked at this term date, because I was like, well, maybe he was coming up on term and he's still a year away, so he can still get into this program and comply with it. We are simply asking the court to consider it on a signature bond here. So Mr. Robbins, I think this has been a wake-up call to him, and I think the court's not going to have any concerns about him complying going forward.
Well, my concern, Mr. Kleins, is, as you stated, he's been on probation since April of 2024. And according to the VOP report, he's told them that every month he advises that he's having trouble finding work to pay for the evaluation. So he's almost 2 years into his probation. He finally seemingly pays for it to get started and then doesn't go.
He is living with his mother. I mean, when I asked for the bond information for the motion, the address, I double checked it with the report, and it's the same address that he's been living at with his mother. I mean, I understand the court's concern. My point being, though, is that I think Mr. Robbins really needed a wake-up call, and he needed to spend some time in jail to understand this is not an option, this is not something that can be delayed, this is not something that gets resolved whenever he feels like getting around to it. And I think that, I mean, he's standing in front of you right now. I think he can assure you, or try to assure you, that he has gotten the message. I mean, he doesn't have any record. I looked at his prior time credit that he had, and I think it's 7 days back in 2021. So this is the longest he's ever been in jail.
Well, I understand those things, Mr. Kleins, but Mr. Robbins, do you understand that violations are something to be taken seriously?
Yes, I was unaware at first.
Okay. And to be honest, I'm almost surprised it's taken this long to get to this point. So, and maybe that's part of the problem I don't like to violate people for monetary issues, especially not quickly. But I think 2 years of not signing up for the psychiatric evaluation and treatment is probably a bit too long. And then again, once it's finally, the evaluation's done, they recommend treatment, and then you don't show up 3 straight times, is the allegation. Again, it hasn't been proven, you haven't admitted to that. I'm not asking you to admit to that. I'm just making sure you understand that this is an important thing to take care of, Mr. Robbins.
Yes, Your Honor, I was unaware of it, but it's shown me.
Okay.
What I would suggest, Your Honor, is if the court grants the motion, put Mr. Robbins on for the later date in April and require that he show proof that he's at least started attending these sessions. I mean, that's the point. That's why I'm asking him to get out on bond, so we can
All right, let's do that. I'm going to grant Mr. Sprouse.
Yes, the victim in the underlying charge is here. He has concerns about the defendant not taking this seriously. I know that he wants to address the court. I told him right now it's probably not the best time to address the court.
Well, usually that would come up before the stipulation to the signature bond.
He showed up today to discuss that he believes this is serious. It doesn't change the state's stipulation.
Well, it may change whether or not the court accepts it.
Exactly. That's why I'm bringing it to Your Honor's attention.
Okay. All right. Is that individual here?
Yes, it's Mr. Lewis.
Mr. Lewis, come on up. You can stand at the podium right here, Mr. Lewis. All right, Mr. Lewis, you're the victim in the
Yes, sir.
failure to stop in an accident involving injury. All right, what would you like to tell the court?
Your Honor, I want to thank you for allowing me to speak today. My name is Keith Clyde Lewis. I'm a resident of Baker, Florida. I am the victim of the hit-and-run accident by Devin Robbins, and the reason he is on probation. When the criminal case first started, he was initially going to be charged with a second and third-degree felony. Efforts by the state's attorney's office and my personal attorney with an ongoing case, the second-degree charge was dropped. As a direct result of this hit and run, I have suffered multiple injuries that include a torn rotator cuff requiring major surgery, a level 4 torn AC joint that severed the 3 tendons that hold your collarbone in place. The surgery also included the placement of a lasso to hold the collarbone and the surgery also required removal of a piece of the end of the collarbone. I have bilateral Jones fractures in my feet, and I'm scheduled to have surgeries on those this year. I have a broken big toe that has permanently deadened the nerve, and therefore my foot thinks that the toe is gone. As a result, I have no balance in that foot, and when I walk, essentially none of my toes touch the ground. I have neuropathy in both feet, requiring continuous medication. Indirectly, because of the way I have to walk, I've had to have a right knee replacement. This year, I will also have to have my left knee replaced. This is a basic description of my physical problems. Mentally, what I went through as a cadet at the United States Air Force Academy, there is no comparison to my the last 4 years, attempting to cope with ongoing pain and suffering. This event has ever taken away the quality of life I once enjoyed. Do I regret agreeing to drop the second-degree felony charge? I continuously question that on a continuous basis. I don't understand how someone with a felony charge, along with numerous speeding violations, is able to hold a Florida driver's license. Your Honor, I am asking that you, in your final decision, to consider the quality of life that was taken away from me and the pain and that I continue to endure. Additionally, I ask you to consider to revoke parole and sentence Devin Ernest Robbins to prison for as long as the state law allows, or based upon your decision. Thank you, sir.
All right, just to make sure you understand, Mr. Lewis, and I appreciate what you've told the court. He's on probation, which was something that was agreed upon certainly before I took over the case. And
Yes,
I don't know, like Mr. Klein's attorney said, I don't know why it took 3 years either. He wasn't part of the case at that time. At least I don't think you were, Mr. Klein's. I assume you weren't, because you were in another division with a different agency.
I have no idea why it took so long.
Okay. But he's only on probation for the leaving the scene. And I don't know why. I'm trying to read it quickly because, again, this is
I don't know
from,
exactly how everything played out, but I guess dropping that second-degree felony
Yeah, I
must
understand.
have changed something as far as it being a hit and run. I was physically hit.
yeah, I now have read that, which is, I was kind of surprised. You don't see those charges go together very often. So I don't know why the state made that decision as part of a plea agreement at that time. I would guess, unless there's some old notes in there, the current state attorney might not have that information because, again, none of the people who were involved in this case now were involved then. But he's only here on the leaving the scene, and his violation is for not completing some psychiatric therapy sessions. And so unless he enters a plea or we have a violation of probation hearing, I can't just revoke his probation and send him to prison. That's, that would have to be a situation where there's either, again, a plea or a hearing as to, I'll make that determination. So I can't just revoke it like you've asked. Okay. All right. Thank you, Mr.
Thank you for
Lewis.
your time.
Yeah, I mean, that's unfortunate to hear. As he was speaking, I was reviewing the plea agreement. There's no restitution that's ever been ordered in the case. I don't understand why with all these medical issues, but I mean, there's also a reason why Mr. Robbins has been ordered to undergo psychological evaluation and testing and possible treatment here. So, I mean, he's got mental health issues of some kind. Mr. Robbins, I mean, I think you need to fully grasp what's going on here. Like, I have the state attorney who's saying, yeah, I'm cool with the signature bond, and I have a judge who's saying, I don't know, I am, So I think you need to really reevaluate what you're doing with your life. I mean, the judge is making some fair points. If it takes you 2 years to get into some evaluation has been ordered, that you agreed to. Like, that's the whole reason I'm asking the court for a bond here. So you need to give the court some assurances here that if the court lets you out on bond, your first stop after you meet with probation today would be to the Bridgeway Center to get back into the program. Because that's the only reason I'm asking for this bond, is so you can get out and show the court and show this victim that you are serious about doing the right thing here.
Yes, I do want to get out so I can, like, being in jail has woken me up, and I don't want to ever make a mistake like that again.
So what I was saying, Your Honor, essentially is, if the court grants the motion, order him to report to Bridgeway and order him to show proof at his next court date that he's engaged in the process and not missing appearances.
All right. I want to accept the stipulation to be the $1,000 signature, but Mr. Robbins, what I'm going to order that you do is I'm going to have you come back, actually sooner than that, April 9th at 9 o'clock for status as to whether or not you've signed up for that, for Bridgeway. And unless you can show me some reason why you weren't physically able to do that, we'll talk about whether or not that bond's going to stay in place. So you've got 2 weeks to figure this out.
And the defendant's actions on doing the evaluation before a hearing or plea also weighs on the state's offering decision.
All right, so what the state's saying to you is your actions in the next 2 weeks is going to change whether or not they seek, certain types of punishments, and then certainly it would also reflect on whether the court's going to agree to whatever, if there's a plea agreement done, if I'm going to accept it or not, or if you go forward on a hearing, if you were found to have violated your probation, as to what your sentence would be. So time is of the essence, Mr. Robbins. You have 2 weeks. We'll see you back April 9th, 2 o'clock.
Thank you, Your Honor.
Have that evaluation figured out or be re-enrolled. I'm sorry. Go meet with, hold on. He's going to meet with probation. 9 o'clock, did I say? What did I? 9 o'clock.
You said 2, and I know I have a ton of stuff.
I think I said 9 o'clock the first time, but it's 9 o'clock. Sorry if I got that.
Okay.
But thank you for clarifying.
Yes, sir.
April 9th, 2 o'clock. I just did it again.
Yes.
April 9th at 9 o'clock.
Thank you, Your Honor. That's all I have, if I may be excused.
Yes, Mr. Kleins, have a good day.
You too.
All right, Mr. Maddox, or I'm sorry, Mr. Jarrell, do you just have one, right?
I have 2, Your Honor. But
2.
if we can pass them, I need to speak with Mr. Sprouse about an issue.
Okay. You have who? All right. Mr. Maddox?
Mr. Russell and I both represent Mr. Carroll, Your Honor. Mr. Carroll has this new case that's before the court today, along with Mr. Russell's. He does have a PTD hearing at 12:30, Your Honor, but the state is just seeking a bond if you want to go ahead and move forward on that as well.
Thank you.
So what are we here for on the old case? It's a bond hearing, right?
Judge, on the old case, it's 24 CF 2383. This is a continued hearing on my motion for bond reduction that we had in February. We do have Joseph Carroll's father present to testify. The court really didn't make a ruling last time. We just asked to continue it to get his dad here, but he is here today.
And since that, I would assume it's, I looked at the pretrial detention case. Obviously, it would have occurred before he was in custody, right?
Yes, Your Honor.
All right, go ahead, Mr. Russell. You may have to catch me up to speed as to what happened at the last bond hearing, because it was a while ago.
Judge, we filed a motion for bond reduction January 20th. Essentially, our argument as far as change of circumstances was that Recently, Mr. Carroll's been served with a foreclosure action on the primary residence where he was living at the time of his arrest. All of his personal belongings are at that address. His father is still at the address, and as the court can see, his father is in a wheelchair and would need some assistance to move from that address before they get rid of possession. When I checked the foreclosure, I did not see any activity since the summonses and stuff, so I don't know, I don't think a summary judgment or any of those other hearings have been set yet. But in any case,
Do you have the case number on that again?
I do, Joe.
I know you had it last time. It's all coming back to me now that you've jogged my memory, Mr. Russell.
It's 25 CA 3072.
And what is the father's name?
The father's name is Bobby Carroll.
Okay. And just to agree with you, Mr. Russ, I don't see that anything's been really done other than some summons have been served. There hasn't been any sort of motion for summary judgment even filed, let alone set for a hearing. And I would state that since it's in front of me, I know how these typically work. I would guess at this point, the summary judgment motion would, even if it were filed today, wouldn't be set for probably a couple of months. And even if it were granted, typically sales dates are put out at least 30 to 60 days after that. So it's not an imminent removal at this point, as far as I've seen. If they file something to try to fast track it in some way, I'll keep it to y'all to remember that. But proceed with whatever you want to add, Mr. Russell.
So is the court inclined to deny the motion at this time without prejudice? Once the
I'll be honest with you. I mean, with that kind of time until there's a writ of possession or anything like that, because even once there's a sale done, then that's usually the writ of possession comes up after that.
Yes, sir.
That this is not an emergent situation, and also I'm not quite sure, and even if it were happening tomorrow, that releasing someone with these charges, especially now there's another new charge, again, Mr. Carroll's innocent until proven guilty, but he's got a brand new charge as well that's similar in nature, that some sort of plan can't be put in place to help the father remove his items from the house before any sort of removal.
If that's the court's concern, I guess I would take testimony at this point. That way we won't have to try to bring Bobby Carroll
That's fine.
back. And that at least information can be on the record.
Okay. You want to bring up Mr. Bobby
Mr.
Carroll?
Come on up. You want to just?
Let's just have him there, and if Mr. Maddox, if you could move that microphone in a way that he can use it.
Yes, Your Honor. I think this thing will move down. Is it as low as?
That's the lowest it'll go. All right, Mr. Carroll, can you raise your right hand? Do you swear or affirm the testimony you're about to give us the truth, the whole truth, and nothing but the truth?
Yes,
All right, can you state your full name?
Bobby Joe Carroll.
Okay. Questions for him, Mr. Carroll? Or Mr. Russell?
Mr. Carroll, do you know Joseph Carroll?
Yeah, that's my son.
Okay.
And where are you currently living? What address?
2580 Kinston Road.
That's here in Crestview?
Yes, sir.
And is that where Joseph Carroll was living when he got
Yes.
arrested? Okay. Is anybody else living at that
No,
house
sir.
with you? Okay.
Let him finish his question before you answer, Mr. Carroll. That way I can hear both of you.
I'm sorry. sir.
It's okay. What was your answer?
Oh, no, there's nobody living.
No one else living there. Okay.
There were other people living there before, right?
Yes,
Okay. And none of those people help you move?
no, sir.
Okay. Do you have anybody else that can help you move away from that address?
Well, my brother's trying to help me, and I got a good friend of mine I used to work for, Robert Wilcutt, he's trying to help me.
Okay. And how long have you been waiting for these other people to help you move?
Very long time.
How long is very long? Months, weeks?
Yeah, months.
Okay. Are you asking or advising the court that you need Joseph Carroll out on bond so he can help you move?
Yes.
Okay.
If the owner can.
Do you know if Joseph Carroll's personal belongings, all of his stuff, clothes,
I do
tools,
not know, sir.
do you know if it's still at the house?
I know some of it is, but a lot of it ain't. A lot of it just got took off from there without my permission.
Ah, okay. That's all I had, all the questions I have for Bobby Carroll, Judge.
Okay. State have any questions for Mr. Carroll?
No, Your Honor, he answered the questions I would have asked.
Okay. All right, you can head back, Mr. Carroll. You
Okay.
can go back to the audience.
All right, thank you.
Thank you.
So, Judge, at this time, I don't know if you want to hold this in abeyance until we get closer to a writ of possession, or if you want to go ahead and do
Well,
a
I guess
motion.
where I'm at with it, I mean, they're not, neither of them is the owner of the home that's being foreclosed, right?
Correct. That's correct. I believe it belonged to his mother.
My mom and my uncle.
Okay, so the property we're talking about, Judge, belonged to his mom. That's why he was living there, and that's why Bobby Carroll are living there, is living there.
Okay. I'm not going to find this as a substantial change in circumstances sufficient to address bond again at this point. Now that I've heard from Mr. Carroll, sounds like he's got potentially other help. If it changes, I mean, I may reconsider it. I'm not saying I'm likely to reconsider it. I mean, I guess I'm likely to reconsider if there's new information, Mr. Russell, but I'm not sure this is sufficient to change the determination on bond. What is his bond currently set at the old case?
100,000.
Okay. All right, do we want to address bond on the new case since we're here?
Yes, Your Honor.
All right, so let's just make sure we get this done properly. This is 26 CF 570, which is a new case with an allegation from I'm trying to get past all the dates to get to the right one. I guess somewhere around March of 23 to October of 24 is the best I can tell by reading the arrest affidavit. I read it yesterday.
That's my understanding, Your Honor.
Okay, he's charged with, Mr. Carroll, you're charged with sexual assault by someone over the age of 18 against a victim under 12. Do you understand that?
Not really, but
Do you understand that's what you're charged with?
sure. Yes, sir.
He's not being flippant, Your Honor. That's the answer that he's given me. He has expressed his lack of understanding. I read the statute to him. I've tried to clarify some things. I met with him this morning. Still have to iron some stuff out. I'll keep an eye on it, Your Honor.
Okay. All right, and the state's not pursuing a pretrial detention at this time?
Yes, Your Honor, just would like to be heard on the bond conditions possibly.
Okay, go ahead.
The state would ask for 200,000 cash or professional, GPS monitor, no contact with minors at all. I want the court to be reminded that in the past already, from the jail, Mr. Carroll violated the condition of bond by contacting a minor child that was not his biological child. That's the reason why I'm asking no contact with minors whatsoever.
All right.
And Judge, if the state is referring to the video visitation, that was before this court made the clarification that it can't be with kids that aren't his biologically or that he's not on the birth certificate. Judge Gonterick, when he gave him the original bond in my case, it wasn't clear.
Okay. And I have a note too, there was, again, this was before my time in this division, but back in November of '24, and I say this because my notes indicate that there, for some reason, there's no order or court minutes from that hearing. But I went back and watched it, and then I put notes into my file that the hearing actually did occur, and the state had proffered there was a jail call where the defendant had stated he was planning on leaving Okaloosa County. I know Mr. Carroll disagrees with that. I'm just making sure that, my notes are clear as well. And then we readdressed it, I believe in March of last year, as far as the old case. As far as the new case, Mr. Maddox, do you want to make an argument as to bond?
Yes, Your Honor. Defense is asking for a $100,000 cash or professional bond with any safeguards that the court deems appropriate, Your Honor. I'm not familiar with the proffer or the allegations that were made as part of that case, but it sounds like, at a minimum, there was some clarity that needed to be had on the bond conditions. So we're asking for a $100,000 cash or professional bond, Your Honor, on this case.
All right, Mr. Carroll, it's going to be a $200,000 cash or professional bond, GPS monitor to be hooked up before you're ever released, no contact with the alleged victim. In this case, no contact with any minors whatsoever.
Thank you.
Thank you, Mr. Carroll.
Thank you, Your Honor.
All right, who do we have next? Mr. Russell?
Judge, if I could address Nicholas Atkins, he has 3 cases on your docket, 23 CF 373, 23 CF 531, and 24 CF 1457. These cases were set for a status. We were waiting for a second eval from Dr. McDonald. They do have an appointment with Dr. McDonald, but it's not till May 19th. I waived Mr. Atkins' appearance because they told me, and I confirmed with Dr. McDonald's office, that in fact that is the appointment date. So what I'm asking to do today is reschedule this to, I was looking at your schedule, I'm thinking June 2nd at 9 a.m. to give the doctor to give her some time to generate a report after the meeting.
All right. State, any issues?
No issues from the state, Your Honor.
All right, June 2nd, 9 o'clock for the status on competency evaluations.
Thank you, Judge.
Anything else, Mr. Russell?
Not for me, Your Honor.
All right.
You need him.
Booker? Booker? Booker Flex.
Oh, there you
All right, this is Rhonda Booker, 21 CF 401, violation of probation.
Yes, Your Honor, we've reached a resolution in this case. If I could just have a brief moment to go over it with Ms. Booker. Your Honor, may I approach?
Yes. All right, so it's a new 11 months, 29 days. So when does that start?
Yes, Your Honor. It is a new term of 11 months and 29 days that will start today. She'll need to comply with ECLC in the jail. Upon release, she'll have 6 months. That'll be a new term of probation. The prior term of probation will be revoked and terminated. She'll need to complete a substance abuse evaluation and any recommended treatment.
Okay.
Any issues with that, Mr. Sprouse?
No.
All right, Ms. Booker, can you raise your right hand? Do you swear or affirm testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, can you state your full name and date of birth, please?
Rhonda Day Booker, March 3rd, 1984.
And this is a downward departure as well?
Yes, based on a legitimate uncoerced plea.
All right, Ms. Booker, as announced, 21 CF 401, you're here on a VOP. The agreement I have calls for you to admit your violation, revoke and terminate your current probation. You'd be waiving any prior jail credit, so your 11 months, 29 days sentence would begin today in the Okaloosa County Jail. While you're in the jail, you're to comply with the ECLC program, followed by, once you're released, 6 months of a new term of probation. We'll have to complete a substance abuse evaluation, any recommended treatment, $100 VOP fee, $150 cost of defense, waive cost of supervision, be adjudicated guilty. All of your sentences between the 4 counts would run concurrently. Is that your understanding of the agreement?
Yes, sir.
Is that the state's agreement?
It is, sir.
Okay. All right, have you gone over this agreement with your lawyer?
Yes, sir.
Did you understand and sign it?
Yes, sir.
And are you satisfied with your attorney's advice and representation?
Yes, sir.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues?
No, sir.
Has anyone forced, pressured, or threatened you in any way to enter this plea?
No, sir.
Has anyone promised you anything other than the terms of the agreement I just read?
No, sir.
And do you understand by entering this admission to your violation of probation that you'd be giving up your right to have a hearing where the state would have to prove that you violated?
Yes, sir.
And do you understand you're waiving any potential defenses that you may have?
Yes, sir.
And what is your plea? Are you admitting or denying your violation?
Admitting.
And accept your admission as freely, voluntarily, knowingly given, revoke and terminate your previous probation, sentence you to a new period of 11 months, 29 days in the county jail. You're waiving your credit for time served, correct?
I am.
Okay, and while you're in the county jail, you're going to comply with the ECLC program.
Yes, sir.
Once you're released, that'll be followed by 6 months of a new term of probation where you're to complete a substance abuse evaluation and any recommended treatment. There'll be a $100 VOP fee, $150 cost of defense, waive cost of supervision, adjudicate you guilty, all sentences to run concurrent. This is a downward departure where you scored 29.7 points.
Yes, Your Honor. Or
I'm sorry,
29.7
29.7 months,
Yes.
excuse me.
And if I may, Your
And
Honor.
the basis of that is a uncoerced plea bargain.
If I may just quickly correct something, Your Honor.
Yes, please.
She pled initially to 2 counts, the second-degree felony, the burglary of an occupied dwelling, and a theft charge, that was a third-degree felony. The other 2 counts were not pled to, so those are the counts that are being contemplated in this plea. She has a maximum exposure on those 2 counts of 20 years.
Okay. Yeah, I've got the burglary, grand theft, and then 2 vehicle thefts. So
I
you're
don't-
saying which ones were
The
not?
2 vehicle thefts were not pled to.
Usually they don't show up on the docket when they weren't pled to, but
The clerk's website that I'm looking at shows guilty on 2 charges, the burglary, Your Honor, the second-degree felony, and the theft, the $300 or more but less than $5,000, that's a third-degree felony. Correct me if I'm wrong, State.
that's what I'm seeing now that I'm looking up here, but I'm just saying usually, I thought on the paper dockets, they usually take them off.
They do, that's why I wanted to make sure that was correct.
All right, Ms. Booker, you have 30 days to appeal the judgment and sentence of the court. I'm going to have you talk to probation quickly just because you'll be on probation once you're done. I'm going to send your monetary to collection. Is that what you're asking, Mr. Berry? Or you have something else?
Well, the agreement is to bring her out on 6 months of supervision?
Correct.
I know, Ms. Booker, I know that originally she owes about $17,000 in restitution. I don't know we're just coming right back on a BOP if we're asking for her to have to do that.
Well, my understanding of the way the agreement was structured between the state and Ms. Booker was revoke and terminate her previous probation.
Okay.
So that probation with that term is over.
All right.
Correct.
Which is why I was about to talk about monetary conditions. And then the new probation, according to the paperwork, doesn't include that.
Correct. Restitution
Go to judgment.
would go to judgment, correct?
Okay.
Because
So monetary on the old probation will go to judgment and collection, and then it wouldn't be a condition of her new probation, is the agreement that y'all have made.
Yes, Your Honor.
Yes.
And Your Honor, just to clarify one more thing, she's gonna come out on 6 months probation. Is the court or the state good with her continuing ECLC in lieu of the substance abuse evaluation and treatment at Ridgeway?
I don't have any issues with that, but I'll leave that to Mr. Sprouse.
There would have to be some sort of evaluation. The point of the probation is to make sure that ECLC stuck.
Okay.
She just needs to be reevaluated, right, when she gets out.
Okay, that's fine.
No problem.
It can be kind of probation's discretion based on how she is when we get to that point.
No problem. Thank you, Judge.
Yeah, so just make sure you're doing what they're telling you to do.
Absolutely. Thank you.
Thank you.
Thank you, Your Honor. Your Honor, this is Ms. Cox before the court in 20 CF 3038. I am asking for a continuance in this case to the next miscellaneous date without subpoenas, Your Honor. I'm looking into possibly doing a mitigation report on Ms. Cox. I need to talk with Dr. McDonald about that, Your Honor. I also have some additional investigation I'd like to do based on my meeting with Ms. Cox yesterday, Your Honor. So I am asking for a continuance in this case. I did talk to Mr. Sprouse. I don't believe he has an objection.
I do not have an objection.
April 9th or 30th?
30th, please, Your Honor.
All right, April 30th, 9 o'clock, no subpoenas. All right, thank you, Ms. Cox. Back to Mr. Arp.
What is this? Oh, thank you.
Go ahead, Mr. Maddox.
Yes, Your Honor. This is Mr. Arp, 22 CF 1833. At this time, we'd like to set this case for an evidentiary hearing on April 9th with subpoenas, Your Honor. I've spoken to the state about it. I believe that date works for them as well. The only thing on my end that I did speak to the state about and would like to inform the court about for the court's benefit, Your Honor, is I do believe I will file a motion challenging one of the conditions of probation, but I believe we could handle both that and the hearing itself on April 9th as they would.
I don't understand what you're saying. What are you're going to challenge a condition of probation?
Yes, Your Honor. I believe I'm going to file a motion under 3800 challenging condition 8 of Mr. Arp's probation.
Based on?
Based on it being an illegal condition of probation or an unannounced special condition. I'm still looking into the exact best ways procedurally to do that, but I did want to inform the court that I should have that filed before April 9th well in advance so that the court can review it, and I've talked to the state about that as well.
So what, you said condition 8?
Yes, Your Honor.
That he has to work?
No, Your Honor. As part of condition 8, it requires him to advise his employer of your probationary status. There is a case that recently came out of the 3rd DCA in 2025, Capazzi v. State, 417 Southern 3rd 409, Your Honor, that explains the argument that I'm going to make.
All right, we'll make it in a written motion, but I don't think we should be in a situation where no motion's been filed and you want to argue it as VOP.
No. I'm going to file a written motion, Your Honor, and argue the written motion and then do the VOP hearing. I believe we can accomplish those both on the same day. Apologies if
In 2 weeks, despite the fact you haven't filed it yet. I'm usually not in the habit of setting hearings on motions that haven't been filed. Just so that everyone is put on proper notice as to what's being set and they can prepare for it. I mean, what if you don't file it for another 13 days and we come back in 2 weeks?
I will be out of town over the weekend, but as soon as I get back, which would be Wednesday, I have most of the groundwork done on it, Your Honor. I would file it around then, and that would give us several days to prepare for it.
Several whole days. State's position?
You know, if the court is fine, the state is okay, as long as I get a motion even a couple of days before. I have to advise also that I spoke with Mr. Maddox about it, so I know what he's
Okay.
arguing, and it's a sort of a very narrow issue that shouldn't require that much time. And certainly not testimony, it's just a legal argument.
Okay, I'll take a look at it, but file a motion, and if you can send a courtesy copy to my office, Mr. Maddox, that way I make sure to read it in advance. Because if you don't file it until such a date, you may not appear where I can see it for another, 3 days.
Yes, Your Honor. First of all, I apologize to the court for putting that on the court. But
don't
I
have
did
to.
figure that I would have enough notice to do it. Like Ms. Leone said, I do believe it's a relatively narrow issue that shouldn't take too much time to flesh out. I will provide the court with the case law and a brief summary of anticipated arguments so that the court can do its research. I will also provide that to the state in preparing for the motion hearing and in consideration of the motion hearing.
Okay. Any issue with sending it 2 weeks out?
No, Your Honor, I have time to subpoena.
Okay. All right, April 9th at 2 o'clock for the evidentiary hearing. Once the motion's been filed, you can do a notice of hearing on that as well.
Yes, I will, Your Honor.
All right, thank you.
Boykin?
The motion? Oh, this? Sure, yeah. Hey, Mr. Boyd. All right. Your Honor, this is Mr. Boykin before the court in 25 CF 1524 and 25 CF 1525. Excuse me. As the court may recall, there were some difficulties in taking Mr. Boykin's plea. Your Honor, I have spoken with Mr. Boykin extensively about the plea, extensively about the services I've rendered. He's informed me that he has no issue with my services, that he has no issue going forward on this plea agreement. I spoke to him about the date of birth issue. He's going to state his date of birth on the record. I don't believe there'll be any further issues with that. He's also told me that his date of birth is on the birth certificate that he has and on his driver's license. I'm taking him at his word on that, Your Honor. With that, I do believe I've ironed out all the issues that would have prevented the court from accepting this plea and would like to go forward on it today if the court is so inclined.
Sure.
If I may approach.
Yes.
Do you still have the score sheet? I'm sorry.
I do, yes.
Yeah,
The same
no.
plea from before.
Yeah, that's fine.
Okay. Thank you.
All right, Mr. Boykin, can you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth? All right, can you state your full name and your date of birth?
Charles Earl Boykin, 7859.
Which is what I have on my docket. All right, and Mr. Boykin, you're here in 25 CF 1524 and 25 CF 1525, where you're charged with failure to register in each case. I've been handed a plea agreement that calls for you to plead to the 1524 case. In return, it'd be 5 years Department of Corrections with credit for all time served, adjudication of guilt, 150 costs of defense, 515 court costs. Those costs would go to judgment. You're going to get credit for time served, including, I think we talked about this time, the time you spent in Covington County Jail from July 3rd of 25 to July 22nd of 25. And that was based on what Mr. Maddox had provided last time, which was correspondence from that jail that he was in the Covington County Jail only waiting to be transported here on the warrant, right?
Yes, Your Honor.
Okay. And then in the 1525 case, that would be dismissed by the state, correct?
That is correct, Your
All right, is that the your understanding of the agreement, Mr. Boykin?
Yes, sir.
Okay, anything else you wanted to say? You look like you want to say something while I was reading it.
No.
I just wanted to make sure I didn't miss anything. All right, Mr. Boykin, have you had enough time to go over this agreement again with your lawyer?
Yes, sir.
And did you understand and sign the agreement?
Yes, sir.
I've given him a copy as well, Your Honor.
Okay. Okay, and are you satisfied with your attorney's advice and representation in this case?
Yes, sir.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues? Has anyone forced, pressured, or threatened you in any way to enter this plea?
No, sir.
Has anyone promised you anything other than the terms of the agreement I just read? You understand by entering the plea, there won't be a trial of any kind?
Yes, sir.
Do you understand that you're giving up your trial rights, which are on page 2 of that agreement that you've signed?
Yes, sir.
And you understand that you're waiving any potential defenses that you may have?
Yes, sir.
Do you also understand that if you're not a U.S. citizen, this could lead to your deportation or exclusion from the country?
Yes, sir.
All right, and what is your plea to 25 CF 1524, failure to register?
No contest.
All right, I'll accept your no contest plea as freely, voluntarily, knowingly given. The state have an announcement on 1525.
State dismisses their case in exchange for a plea to the other one.
Okay. It's going to be adjudication of guilt on the 1524 case, 5 years Department of Corrections with credit for all time served, including time spent in Covington County Jail from July 3rd of 25 to July 22nd of 25. It's going to be $150 cost of defense, $515 court costs. Those costs will go to judgment. Mr. Boykin, I'll need you to be fingerprinted, and then you have 30 days to appeal the judgment and sentence of the court.
Judge Mono, what you, is that, you talk about that, price of, since I'm going to, prison for this time, when I get out, do I have to pay them, is that a fine?
It's court costs, and hold on a second. Was there?
817.
Oh, it's $817 court costs
For the failure to register,
for
Your
the
Honor?
failure to register. They'll be sent to judgment, so it'll be a judgment against you, but you won't be violated in some sort of probation or anything if it's not paid. It'll just be like a judgment against you that has to be paid or can be collected.
Okay, all right.
All right, anything else, Mr. Boykin?
No, I didn't understand that.
That's fine, that's why you're allowed to ask questions, and I'll give you the best answer I can give you.
Okay.
But I do need you to
So
be
I ain't got
finger.
no time frame to pay that when I get out, I just,
No, it's just
No,
like, it's like an unpaid debt.
Right.
oh, okay.
So, you know, if you go to try to borrow some money, it'll show up as an unpaid debt, and the people you're trying to borrow money from might not want to do that because of it.
Okay.
Okay? But I do need your fingerprints, Mr. Boykin, then you have 30 days to appeal.
Thank you, Your Honor. And then
Thank
I
you,
did
sir.
inform him that he's still required to comply with any registration requirements that he's bound by.
Oh, do I have to, when I get out, do, as long as I can register in any state? I ain't gotta stay in
You'll
one
have to
state?
follow the laws of that state.
Okay, that's what I was just saying, that's why,
Okay.
okay.
Your Honor, I can try to help Mr. Boykin. Mr. Boykin is always tried to comply,
Yeah.
but what Mr. Boykin, I think is what he's asking or is trying to get through, is that when he gets out of Florida DOC, he's gonna come out, not on paper as they
Not on
call it to
probation.
us, but he's gonna come out on a release program from the prison.
Yeah.
And he's gonna have to provide name, address, phone numbers, and all that. Mr. Boykin, if you want to live in Alabama, let them know in prison that you want to live in Alabama, and they can transfer you to Alabama, and that way you don't come back to us and come out homeless as we usually do, okay?
Oh, okay.
You got me?
All right, now I understand.
Okay. Thank you, Mr. Berry. All right, who do we have?
Your Honor, Mr. Foreman had a counteroffer that he'd like me to make to the state. If I could just pass him to talk to the state about that, we may be able to work this case out today.
All right, let's pass Mr. Foreman, we can bring him back later.
Thank you, Your Honor.
All right.
I wanted to wait till you had a decision.
That's fine.
Okay.
Just let me know.
I will.
Yep.
Thank you, sir.
Have a good one.
All right, you'll be back this afternoon.
We'll see you back later today.
Thank you.
Your Honor, this is Mr. Franklin before the court in 24 CF 151 and 15 CF 1363. I have some reciprocal discovery that I need to provide to the state on this case. I do believe we'll be able to resolve it based on my conversation with Ms. Leone. If we could pass this case to, or not pass it, if we could continue this case to April 9th without subpoenas, so I can provide her the reciprocal discovery in anticipation of a hopeful resolution.
That would be fine, Your Honor.
Okay.
All right, do you understand that, Mr. Franklin?
Yes, sir.
All right, we'll see you back in 2 weeks, April 9th, 9 o'clock, no subpoenas.
All right, thanks, sir. I think that's everyone I have. Do I have any? Good.
All right, Mr. Williams, is he set up?
Do we have Mr. Durrell's clearance? Are you about ready? Can we get his, or? Mr. Williams, why don't you do whoever they've got up, and then?
Durrell.
Oh, you do have Durrell. Okay, I'm sorry. All right, Mr. Durrell.
May it please the court, Justin Durrell. Your Honor, this is Mr. Eugene Carter. I believe we are close to a resolution. Mr. Carter does have a couple of issues he'd like me to look into. That's what I was trying to discuss with Mr. Strauss. We weren't able to reach a conclusion this morning.
Okay.
I don't believe it will take very long, so if we could have the next available date.
Without subpoenas?
Without subpoenas,
So
sure.
April 9th, it's 2 weeks.
Without objection.
All right, April 9th, 9 o'clock, no subpoenas.
Yes, Your Honor.
Thank you, Mr. Carter.
Yes, sir. And Your Honor, I have also Ms. Nina Gainey, 25 CF 2016, asking for a continuance for Ms. Gainey. Again, Your Honor, I've been speaking with Ms. Leone. I believe we're close on this one.
Yes, Your Honor, we're just trying to work out some details with the Family First Network and conditions that they would like to see applied on the case for probation.
So this is not a VOP case, right?
It is not. No, Your
We
Honor.
special set this one today, Your Honor, because I thought we were close, and we
Yeah.
are very close. There is just a couple of,
That's what I thought. I had just said plea with a question mark. So,
Yes, Your Honor.
you want to do April 9th?
If we may, Your Honor.
April 9th, 9 o'clock for another possible plea?
Yes, Your Honor.
Okay. All right, is that all you have, Mr. Duro?
It is. Thank you very
All
much,
right.
Your Honor.
Have a good day. Mr. Williams?
Yes.
Hamilton? On to the Blue Act, Mr. Attorney.
Pass you.
Mr. Hamilton's an early plea.
Trying to get to you. Are you in the back here? Thanks. And count 4, the violation of the FWC, that was just by like being somewhere after dark or something?
I don't recall what the details were on it,
Okay.
Judge. It was, I think it resulted from, it's an FWC case. They're the ones that did the situation. And I don't recall off the top of my head now what the violation was.
I've got it as, according to the arrest report. Is violation of wildlife management area regulations, and that a DOD issued permits required for all recreational users of that area. Okay, just to make sure that we're clear and there's a factual basis for it.
Yes.
All right, Mr. Hamilton, can you raise your right hand? Do you swear or affirm the testimony you're about to give us the truth, the whole truth, and nothing but the truth?
I do.
All right, can you state your full name and date of birth, please?
Jeremiah Hamilton, 12/30/1977.
All right, and Mr. Hamilton, you're here in 25 CF 1797, where you're charged with possession of a controlled substance, third-degree felony, evidence tampering, third-degree felony. Those are both punishable by up to 5 years in state prison. Then you have a possession of less than 20 grams of cannabis as a first-degree misdemeanor, 1 year maximum. And the violation of the FWC law that I just talked about is a second-degree misdemeanor punishable by up to 60 days in county jail. Do you understand all that?
Yes, sir, I do.
All right, and I've got the plea and sentencing agreement that calls for you to plea as charged as to those 4 counts. Counts 1 and 2 to be an adjudication of guilt, so that's 2 felony convictions. Do you understand that? 2 years of probation to run concurrently, so a total of 2 years.
Yes, sir.
Substance abuse evaluation or any recommended treatment, or any recommended treatment, or you can comply with the Emerald Coast Life Center ECLC program. You're to do 24 hours of community service, $615 court costs, $150 PD fees. I would waive the cost of supervision due to the fact that you're represented by the Public Defender's Office.
counts 3 and 4, which are the misdemeanors, will just be an adjudication of guilt and time served. Do you understand that?
Yes, I do.
All right, and have you had enough time to go over this agreement with your lawyer?
Plenty.
And, okay, did you understand it and sign it?
Yes, sir, I did.
And are you satisfied with your lawyer's representation and advice in this case?
200%.
200%. Is that a record for you, Mr. Williams? 200% is pretty good. Okay. Usually I get about 110%. So. All right, and Mr. Hamilton, are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues? Has anyone forced, pressured, or threatened you in any way to enter this plea?
No, sir.
Has anyone promised you anything other than the terms of the agreement I just read you?
No, sir.
And do you understand that by entering this plea that there won't be a trial of any kind?
I do.
And you understand you're giving up your trial rights, which are starting on page 1 and going over onto page 2 of that agreement that you've signed?
Yes, sir.
Do you understand you're waiving any potential defenses that you may have?
Yes, sir.
And do you understand that if you're not a U.S. citizen, this could lead to your deportation or exclusion from the country?
Yes, sir, I do.
Okay. And what is your plea as charged?
No contest.
I'll accept your no contest plea as freely, voluntarily, knowingly given. As to counts 1, adjudication on all counts. As to counts 1 and 2, would be 2 years probation to run concurrently. Substance abuse evaluation and any recommended treatment or the ECLC program. 24 hours community service, $615 court costs, and $150 in PD fees. Waive cost of supervision. Counts 3 and 4 will be an adjudication and time served. Mr. Hamilton, I'm going to need you to speak with probation, who's sitting there behind you. I also need you to be fingerprinted on your way out, and then you'll have 30 days to appeal the judgment and sentence of the court. This is a guideline sentence, as Mr. Hamilton scored 29 points. All right, thank you, Mr. Hamilton.
you.
Good luck.
Thank you, sir.
Ingram? Got the black ticket.
Judge, I do have one out that is going to be a plea. It was originally set for a motion to suppress.
Who's that?
That's going to be Mr. Henderson. If we can maybe take him next, get him out of here.
We'll talk about that.
Judge, Mr. Ingram is here for a regular bond hearing that I
Okay.
filed on him. There was also an issue where it was a little bit past 33 days, but the state has filed the information. He's also got an arraignment scheduled for this afternoon, and I'll go ahead and arraign him this morning.
Okay. So I've got this as the 26 CF 376. It's all just the one case, right?
Yes, sir.
Okay. All right, I think this was a situation, it was set at first appearance as a pretrial detention hearing or the bond if it hadn't been filed.
Yes, sir. That's exactly correct. And
No
he was
motion.
advised that he could go ahead and seek a bond reduction later.
All right. All right, so he certainly, he currently has a $15,000 cash or professional bond?
That's what I have, Judge.
Okay. All right, what would you like to tell me about Mr. Ingram?
Judge, basically what's in the motion, if court needs to hear from him directly, I can do that. But we're requesting a bail of either $2,500 or signature. He does live in the area. He lives with his father. He's been in the area for about 9 years. We're simply seeking to have him be released on bond in terms of any requirements that the court has with regard to staying away, GPS, anything, exclusion zones, anything like that, we'd be compliant with it.
63.
All right, State.
Yes, Judge. I think a $15,000 bond for the charges is reasonable. I will let the court know that the victim in this case is currently incarcerated for battery against his mom and grandmother.
But just to make sure I'm clear with that, the alleged victim is in jail for offenses committed against his own
Yes.
mother.
His own mother. There's a reason why it took.
I just want to make sure if it's one of the, if you were saying against Mr. Ingram's mother, that would be different potentially. So that's, I'm just making sure I'm clear.
Yes, Judge.
Go ahead.
There's a reason why the state took an extended period of time on filing on this case. When we first spoke with the victim, he said he didn't know whether or not he wanted to move forward with the case. There's some evidentiary issues, so essentially I don't know how this case is going to get resolved. So The state's position is, it's up to Your Honor.
Obviously, Judge, I wasn't aware he was incarcerated. I'd have mentioned that if I'd known that. But obviously, Judge, if he's incarcerated, then it's not going to be a situation where he needs to worry about Mr. Ingram being released and in any way or anything like that.
In addition, we would just ask not to go back to the residence where where the victim lives.
Jeremy Holly, is that it?
That's what I've got on the information, Judge. It's a Jeremy Justin Holly.
Looks like you just had first appearance.
2 days ago, 3 days ago, something like that. Yesterday, the victim's case was not on the clerk's website when I checked. I did speak with the victim.
Looks like he's got a $100,000 bond.
Right.
What about Mr. Ingram's criminal history?
Mr. Ingram does have criminal history.
Okay, and what might it be?
I couldn't tell you off the top of my head, Judge.
Judge, I've not independently sought any information on his criminal history. I generally defer to the state on that. And it's early enough in the case, I don't have a score sheet or anything like that yet. At least I don't think I do. Yeah, it looks like what I've got is the arrest report and the stuff that I printed out concerning the docket and things of that nature.
So I'm just trying to figure out where the issue is with, for some reason, it's coming up on the clerk's site as aggravated battery with a firearm discharging a firearm, which obviously is not the circumstance.
Not in this case, no, Judge.
But that's what it's listed as, which is why when I'm reading it, it's about a wooden decoration and not a discharged firearm. And those obviously change the things that I would think about.
Yes, sir.
Based on my reading of the probable cause affidavit, I read that yesterday as far as the facts of the case. I'm not saying I necessarily agree with the state or disagree with the state, but there are some issues as to what happened and what witnesses were present for it. I will give the $2,500 cash or professional bond, no contact with the victim, Mr. Ingram, and do not possess any weapons or firearms while you're out on bond.
Yes, sir.
Anything else?
No, Your Honor.
All right.
So it means it's going to be your responsibility to
It
make
might
the
already
appointment.
be a condition, but no contact with the victim.
I did say that. But same conditions, other than it's just a reduction of the 15,000 to 2,500.
Yes, sir.
Thank you, Mr. Ingram.
There you go, sir.
Oh, and did y'all get a copy of the information?
I
You do
did
have
get
it?
his
Okay,
copy.
perfect. And you've entered a
I
plea of
printed
not
one
guilty, so let's
myself,
put him on April 29th at 9 o'clock. If he bonds out, we can have him on the 27th at 1.
All right, Judge, if I can go, Mr. Hamilton, or Henderson, I swear I'm trying to get to you.
Call him when you're ready.
Well, we've already got this gentleman out. This is going to
So
be
next will
a
be Mr. Henderson.
negotiated plea as well. This is William Lawrence. Spoke with the state earlier. We're going to send him to Project Hope. Mr. Lawrence, this is the plea agreement with the rights form that I went over with you back in Longmont. And Judge, it's a modification and extension. It's going to be to extend it 2 years, complete any remaining outstanding requirements, plus do Project Hope. He's been accepted in Project Hope. We do have an acceptance letter that the state's seen, and that will serve to complete any drug treatment, outstanding drug treatment, if there is any outstanding drug treatment on his probation.
So what's the plan? Is he going to be released directly to Project Hope, or is he going to be released to go to Project Hope?
I did talk with the gentleman from Project Hope yesterday. Once he's released, if somebody will simply call them, they'll actually get somebody to come pick him up from the lobby of the jail.
That's what I'm just trying to make sure, because, you haven't admitted it yet, Mr. Lawrence.
Sorry, Judge, it would be bars to bed, correct?
Okay.
Okay.
Bars to bed, all right.
The letter indicates they will transport him.
Okay. It's just, admission, at least to probation, that he was using fentanyl, methamphetamine, amphetamine, and cocaine. I don't want this to be a situation where he has an opportunity to make some bad decisions before he gets to his program.
Yes, sir.
Okay. All right, Mr. Lawrence, can you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth? All right, can you state your full name and date of birth, please?
William Ray Lawrence, 6/18/82.
Okay, Mr. Lawrence, you're here in 24 CF 2858, charged with a violation of probation, underlying charges of possession of a controlled substance, 2 counts, and possession of paraphernalia. I've been handed a plea agreement, as stated by your lawyer. It involves a modification of your probation to extend it for 2 years, complete your original requirements, and complete the Project Hope program, and that would be what we call bars to bed, which means you'd be transported directly from the jail to that program.
Understood.
All right. And this is an adjudication, or is it previously a withhold?
I think he was previously.
Previously adjudicated. Was it just on one count?
No, I'm sorry, I'm looking at the other plea agreement, Judge. Someone else handled the other one.
Looks like it's actually just the 1 count of possession of a controlled substance. Am I wrong that the docket used to take those things off?
It was.
No, but I thought even the last time we were in court, that's how it would work. It's got a mind of its own now. It's become self-aware and does what it wants. Sorry, Mr. Lawrence, I'm just trying to, because I told you had 2 counts and another count of a misdemeanor, and it turns out that in your initial plea agreement back in September, that you would plead just to the 1 possession of a controlled substance. And the reason that changes things as to what your exposure is, if you were to violate your probation again, you can get up to 5 years in state prison. Do you understand that?
Understood.
All right, not the 11 that it would have been had you pled to the other 2 charges.
Understood.
So that's why it's important to bring up.
Appreciate it.
All right, Mr. Lawrence, did you have enough time to go over this with
Yes, sir.
Okay. Did you sign and understand the agreement?
Yes, sir.
Are you satisfied with your attorney's advice and representation?
Yes, sir.
I'm just going to cross off those other two counts to make sure we know that's not what it was this time. All right. Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues? Has anyone forced, pressure, or threatened you in any way to enter this plea? Has anyone promised you anything other than the terms of the agreement I just read? Do you understand by entering a plea, you'd be giving up your right to an evidentiary hearing on your violation of probation where the state would have to prove how you violated? And you understand how you're waiving any potential defenses that you may have?
I do.
And based on those things, Mr. Lawrence, what is your plea to the violation of probation? Are you admitting or denying that?
I have admitted to the violation.
Okay. I'll accept your admission as freely, voluntarily, knowingly given, modify your probation to extend it for a period of 2 years. You're to complete all the original terms of your probation and also complete the Project Hope program that will be bars to bed. You were previously adjudicated on that, so I don't need your fingerprints this time, but I need you to speak with probation before you leave the room. You have 30 days to appeal the judgment and sentence of the court. All right.
Thank you, Judge.
Your Honor, is that 2 years
You're
from
welcome.
today or 2 years from his scheduled termination date of 9/1/27?
We said extend.
Extend, so it'll be 2 years from his initial date.
From 9/1/27?
Yes.
That's when he was scheduled to terminate.
Okay.
Thank you, Your Honor.
Judge, if I can call Mr. Henderson up, Jimmy Deal Henderson.
Oh, we actually do need your fingerprints, Mr. Lawrence. Apparently they never took them the last time. Just when you're done, when you're done.
All right, Judge, this is Jimmy Deal Henderson. He's going to be entering a plea to a misdemeanor.
Okay.
It's the no valid driver's license for withheld and court costs.
And this is the case that was set for a suppression motion?
That's correct, Judge.
Okay.
And Judge, I apologize on that. I knew the court had announced that you wanted contested hearings to be in the afternoon. I did not catch that it said 9 o'clock when I signed, or when I
think it got moved, didn't it?
The notice of hearing. I didn't discover he was on for 9 o'clock until I got the docket. I went into a panic and tried to redo the notice of hearing, and that caused even more problems, but we've got it worked out.
Well, the other thing I would say about the case, and this doesn't really have anything to do with Mr. Henderson at all, but is I know you had sent some emails with some photographs that you would plan to use. Unless there's an agreement that those are admissible, I would prefer that nobody sends evidence to me in advance. Unless there's an agreement. For example, if there's a video and it's 30 minutes long, and instead of you all watching me watch it, you send it to me in advance, I'm always happy to watch it early because it saves us all time. But things like photographs, and again, unless they're stipulated to, happens all the time, and other things that I do, particularly family law, they just file a bunch of things and now that's evidence. But if there's an objection to it, foundation, hearsay, whatever it might be, then I shouldn't be reviewing it until there's been a determination as to whether or not it's admissible. Case law is fine too, obviously. I'm always willing to read that in advance. But just going forward, unless there's an agreement to have me view certain things in advance. And if there is, make sure you put that in the email, like, wait, we've agreed to this. So could you please take a look at this before the hearing tomorrow or next week or whatever it is.
Again, I had my note on the docket that said, get photographs in advance, so that's why my son.
Okay.
All right, Judge.
All right, so Mr. Henderson, can you raise your right hand? Do you swear or affirm the testimony you're about to give us the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right. Can you state your full name and date of birth, please?
Jimmy Henderson, October 20, 1970.
Okay, and Mr. Henderson, you're here in 25 CF 1431, where you're currently charged with driving while license suspended or revoked on a permanent basis, which is a third-degree felony and punishable by up to 5 years in state prison. Do you understand that?
Yes, sir.
All right, I've been given a plea agreement that calls for you to plead to a lesser charge of no valid driver's license, be a withhold of adjudication, $300 in court costs, and a $100 PD fee. Is that the agreement that you've made?
Yes, sir.
Is that what you want to do here today? Is that the state's agreement?
It is, Your Honor.
All right. And that's based on the suppression motion that was set for this afternoon?
Correct, Your Honor.
Okay. All right, and Mr. Henderson, did you have enough time to go over this agreement with your lawyer?
Yes, sir.
Did you understand and sign the agreement? Are you satisfied with your lawyer's advice and representation in this case?
Yes, sir.
Are you currently under the influence of any alcohol, drugs, or controlled substances? Are you currently suffering from any mental health issues? You understand that by entering this plea, there won't be a trial of any kind? Okay, and do you understand that you're waiving all potential defenses that you may have?
Sir.
Do you understand you're giving up your trial rights, which are on page 1 and going on to page 2 of the agreement that you've signed? Has anyone forced, pressured, or threatened you to enter this plea? Has anyone promised you anything in return for the plea? And do you understand that if you're not a U.S. citizen, this could lead to your deportation or exclusion from the country? And what is your plea to the lesser included charge of no valid driver's license? I'll accept your no contest plea as freely, voluntarily, knowingly given, withhold adjudication to the no valid driver's license. $300 in court costs, $100 PD fee. How much time do you need to pay that, Mr. Henderson?
Before the end of the year, I'll pay it.
Before the end of the year?
Yes, sir.
I'll give you.
6 months.
I'll give you 30 days to pay it or set up a payment plan with the clerk's office downstairs on the first
Yes,
floor.
sir.
All right. I don't need your fingerprints. Well, I do on a no valid driver's license, even a withhold now, right? Because it's enhanceable because of, okay. So I do need your fingerprints, and then you have 30 days to appeal, Mr. Henderson.
Sir, thank you.
All right, thank you, sir.
Judge.
Statute for no valid 32203.
For no valid, I'm
Come
not sure.
on,
I know
no.
that how it's written, it doesn't matter whether or not it's withheld or.
No, just so we can put 322.03, look at that.
But HTO is not in school. Also no minimum mandatory for HTO.
Well, we don't make the laws. Go ahead.
Judge, this is William Eugene Lee, 23 CF 957. I've spoken to the state. We've got some rough ideas of what the offer's going to look like. She's actually gave me some more specifics later on this morning. I'd like to set him for 4-9 so I can spend some time with him to go over that. It's going to be for county jail sentence and then returning to probation.
All right, so April 9th, 9 o'clock, no subpoenas, correct?
Thank you, Judge.
All right, thank you, Mr. Lee. We'll see you back in 2 weeks.
And I'll come out and go over everything with you between now and then. Yeah, you go ahead and go that way. Judge, the last one I have on the docket is Jacqueline Lige. Judge, I don't see her in the courtroom.
Your Honor, Ms. Lige is currently on supervision with me. I can get in touch with her. I didn't know she had court.
What was it she set for?
I had her on for a VOP according to the docket, and I do have a file for her. And I had this as a VOP arraignment date in 22 CF 2598. If we can.
If you give me an opportunity, she doesn't have a.
Would
She might
4-9
have
be long enough for you?
Oh, yeah.
Okay, tell her to get a hold of me, too.
I believe.
I'm just trying to look at the paperwork because it may have been a warrantless arrest.
Yeah, that is correct, Your Honor. She was warrantlessly arrested for the new charge of petty theft at Dollar General in Christian.
Yes, sir, and I pulled up the docket on the petty theft charge. Her court date is coming up.
And she's been reporting. She's on probation. She is a non-communicant control. I can come by her house. The court allows.
So because of that, she was then given a cash or professional bond on the VOP at first appearance.
I'm showing, looks like her next appearance on the misdemeanor is 420.
That might be her misunderstanding, Judge, but
Say that. 6. And she was arraigned, it looks like March 17th on the misdemeanor. So she may not realize that she's got 2 cases, 2 judges, 2 lawyers she's got to talk to.
I'm not taking up for Ms. Lige, but that could be very much the case for Ms. Lige.
So what are you asking to
I'm not
do
gonna
again,
argue
Mr.
with you
Williams?
on that one.
Mr. Williams, what do
Judge, do you think maybe we can get a hold of her by the 9th? You've got better contact information
I
than
know I
I
can get a
do.
hold of her by the 9th. I'm thinking I can, when I get out of here, I can probably go by her house today if she's home. Tell her that she needs to be up here at 1:30. The court wants to.
Judge, we can recall her at 1:30, or we can just go ahead and set her for the 9th, and then if he gets a hold of her and gets her up here.
Yeah,
by-
she appeared at her misdemeanor case and was given a new court date. So let's put her 4/9 at 9 o'clock.
Okay. And I'll
Thank
make
you,
sure-
But if she's not there on that date, then we're gonna talk about revoking that bond that was given at first appearance.
Understood. I'll make sure I tell her you're up.
All right, thank you.
4/9.
4/9, 9 o'clock.
Judge, that's all that I have that I'm aware of this morning.
Okay. Do y'all have anyone else? Where did Mr. Nopes go?
We will have a resolution on Mr. Foreman, Your Honor, but we'll call him back this afternoon. I'm gonna finish writing it up.
Okay.
Mr. Nopes is speaking with Mr. Parker.
Has anyone talked to Mr. Cobb about Ricardo Bryan? Is that just the case that's never gonna go anywhere? Didn't they transport Mr. Bryan back to the prison for some reason, even though we told them to keep him? Nope, it's not here. All right, let's reschedule and send notice to Mr. Cobb for April 9th at 9 o'clock for a status on Mr. Bryan's case. And I'm gonna try to have my office reach out to him as well.
Is it Stephen?
No, Jason.
I was gonna say Stephen, I've known him for years. I can give him a call.
Careful, might be reason to be a conflict
Well,
of people.
I've actually known him longer than Mr. Etheridge.
Okay.
But, yeah,
Pre-trial detention hearings today?
Yes.
How many are going? I know this is a silly.
I'm usually the one that asks you that.
I know. No motions have been filed. A lot of the cases have bonds on them already. So I don't know if they were released on that bond.
I know, well, there was one case that y'all dismissed already, right?
Yes, Your Honor.
Okay. If there's bonds on them, I mean, I'll leave it up to the defense lawyers if they want to talk about the bonds, but
Well, what brings it up is, I know Mr. Flowers is on one of the cases, and he asked me, like, does he have to be here, even though, because there's a bond on it. I was like,
I don't know, I mean, the only reason to have a hearing would be to, if there was, if y'all want to talk about changing the bond that was set at first appearance, but
They're on their way here, so it sounds like they're still in custody.
Okay, so going forward then, Your Honor, just for, to make sure we're doing it the way that it needs to be done, if we're gonna argue for a different bond, do you want us to go ahead and file a bond motion and address that? Or just address it as we've been doing at the hearing? I just wanna make sure I'm putting the court in a situation where defense is arguing for bonds still, making arguments and then saying, well, there, you know, we didn't really have a shot per se, because we didn't file a motion, we were just here for the normal pretrial detention motion, right?
why don't y'all talk about that amongst yourselves and see if you have any, you know, from your higher ups too, if there's a concern, because if the bond was set at first, and this is a obviously new procedure that we're still kind of hammering out.
Yes, Your Honor.
And we had that meeting a few weeks ago about it. If the first appearance judge says you have 72 hours to file a motion, otherwise here's the bond, if there wants to be any change in that bond, I would guess you'd have to file something and ask for it to be addressed, just like any other bond hearing. Otherwise, it's no different from any other first appearance bond.
And I'll talk to my higher ups, but I would be inclined to agree with court on that, Your Honor.
So we wouldn't be normally arguing that at a pretrial detention hearing, it would go on to any other miscellaneous. Now, if y'all agree, hey, we want to see if we can throw this on to an earlier docket, like a pretrial detention docket, I don't have an issue with that, in theory, as long as it's not a day like, we sometimes have where we're here from 9 o'clock till 6 o'clock and no break in between, so.
Yes, Your Honor. Understood.
What I've seen happen down south with Mr. McKinney is when we have a pretrial detention day, we didn't file on the pretrial detention. Mr. McKinney generally says, I don't have any arguments on bond. Or just leave it up to the court's discretion, because
Okay.
then, it's not